As far as the question regarding disallowing deduction towards power profit, we've answered it in favor of the SSE and against the department. And those appeals of the SSE are disposed of. As regards the periphery development expenses, we've held it in favor of the department against the SSE on the question of consistency. So one appeal, that is 3 of 2015 of the SSE, is dismissed. Two.
No instruction.
All right. Counsel the petitioner states he has no instructions. Disposed of.
Supplementary list item number 3.
None appears dismissed on discussion.
Supplementary list item number 4.
May I please, my lords?
Yes, please.
This relates to
My lordship, apology, my lordship, item 3, my lordship.
Yes, tell
May I
us. Tell.
please, item 3, my lordship. Lordship, PIL matter, my lordship. the representation of the which is pending before the opposite party number 5 and 6, my lord, who is the Tahsildar Kabisujanagar and Executive Officer NSC Kabisujanagar, my lordship.
No, you say eviction of unauthorized occupants.
Yes, my lordship. My
But
lordship,
you've not made any of them. You've not named any of them in the cause title, please.
my
You have to name the encroachers. Otherwise, it's not possible.
I will implementing my lord, the party's name, my lordship.
No,
Give me
not
any
implead here. In your representation, first you name them.
My
All
lordship.
right. You say
My
concerned
lordship.
petitioners seeks to withdraw the present petition, liberty to file a fresh representation to the authorities, naming the alleged encroachers, and after following up on such representation, to seek appropriate remedies in accordance with law. Disposed of his withdrawn liberties.
My lordship, obliged, my lordship.
Supplementary item 4.
May I please, my lords? This is for the assessment year 10-11, my lords.
Right.
The previous assessment year 9-10. The lordship's side order dated 7th of March 2022 have been pleased to admit so
And
far
frame
as
some questions.
questions A and E.
Okay.
The lordship will kindly go through this order and place the matter to the 18th of July.
All right. You say
My lord, I am
admit.
appearing in that department.
All right. Admit.
This is for 9-10. The present one is for 10-11.
All right. The following questions are framed. Mr. Chimanka accepts notice. Same order. All right. And
This is
same day.
Question A and E.
Right.
You know, there's a miscase, my lord, for dispensing with filing of certified copies of 1, 2, and 3.
All right.
What?
Miscase is allowed.
Much obliged.
All right.
And the other one is stay. Your lordship may kindly.
Stay the same thing. Notice on that. All right.
Much obliged.
Ah.
And this matter may come up along with 15 of 2017 on 18th. My lord, that's the date.
18
fixed.
July.
18 July.
Correct.
My lord, extra copy kindly be given.
Yeah,
Yes.
I'll give this to you.
See extra copy.
There's already direction to that effect.
Right.
Much obliged.
Right.
Supplementary item number 5.
Sir, am I audible, sir?
Yes, please.
Sir, I am appearing on behalf of Mr. Shashwat Kumar Acharya. Your Lordship, this is a matter. There are 3 similar connected matters. So, Your
Yes.
Lordship have posted similar matters on 6th of July, while order dated 8th of March.
All right.
ITA 25, ITA 26, ITA 52 of 2017.
This is 26, sir. So that is
The earlier one was 25. Then yesterday there were the ITA 52 was listed. Now today ITA 26. is
all right. List along with ITA 25 and 52 of 2017 on
6 July.
6th of July.
6 July. All right.
Obliged, Your Lordship.
Supplementary list item number 6.
May I please?
Yes.
Here, not the tribunal is held that the jurisdiction of the commissioner under 263 is not permissible because he has no authority to send it back for reconsideration. Therefore, my lord, the relying on the judgment of Delhi High Court is totally different footing. And if your lordships go through the judgment of the Andhra Pradesh High Court in clear case, similar. In paragraph 3 is relevant.
This is Madras High Court, sir.
Yes, Your Honor. Paragraph 3 is relevant because the tribunal is allowed in favor of the revenue. Thereafter, the appellant prefer the appeal before the High Court, and High Court has passed the order against the assessee. Para 3. May I please?
Yes.
The Learned Counsel appearing for the appellant assessee submitted that there is no specific finding to the effect that the assessment is prejudicial to interest of revenue. The Learned Counsel has made a strong reliance on judgment of Apex Court in Malvar Industrial Vice Commission Income Tax and submit that in absence of specific finding that assessment under question is prejudicial interest of revenue, the power under 263 Act cannot be invoked. Then Lordship see the last. This court says that even if not the without specific finding, the 260 power is there to redirect the assessing officer for face assessment. And here the commission, the tribunal is error in law that directing, you'll also see the last finding of the tribunal. Here there is a case not prejudicial interest has been mentioned in the order. There is no there is no other question. You'll also see the last part.
No, erroneous in law, that is not there.
No, here, my lord, the fact remains that the petitioner has not filed a revised return, not disclosing the fact. He is filing a statement that has been accepted by the revenue. Then, my lord, the calculation which has been, that is some loss is there. Therefore, the commissioner has invoked the power under section 263. And you'll also see then first the order of the commissioner, running page 16. In view of the above, assessment order passed under section 910 was considered erroneous in so far as prejudicial interest of revenue. According so cause notice was issued. Then the last part. I have carefully examined the fact of the case record and the submission made on behalf of the assessee. The basis issue in the installed case is the evaluation work in progress and profit element contained therein. In accordance with containing standard 7, which is mandated to the percentage completion method, the profit in respect to WIP was to be accepted as income. The assessee contention is that the same has been done so. The contention of the assessee need further verification. Therefore, the matter is set aside, restored to file the award for redoing the assessment after offering the opportunity to the petitioner. And Lord, why, Lord, I am saying that is a question of law, because the tribunal say he has no authority, he cannot pass set aside this order to the assessing officer for redo the assessment. That is the sole question law. And this judgment is squarely applicable to the revenue.
All right. Anyone appearing for the other side? No.
No, that is first time.
All right. Notice returnable. 26th April. All right.
Oh, bless.
Supplementary item number 7.
Please, my lords. The deficient court fee will be paid in course of the day, my lords.
All right.
And if your lordship would take up my miscase, that will take care of the defect number 5, my lords.
All right.
Miscase at flag A, my lords, for dispensing with filing of annexures 2 and 3.
All right. That miscase is allowed. All right. What's the matter about, sir?
The matter about, my lord, is payment of commission, my lords. The substantial questions of law, my lord, is at page 10. What has happened, my lord, is the petitioner, appellant, my lords, exports iron ore fines, my lords. And after procuring orders, my lord, he collects iron ore fines, my lord. And for this collection, my lords, he has engaged certain people, my lords, to collect it, my lords. Now, the reason for rejection, my lord, is that 7 people, out of 7 people for whose commission has been rejected, 4 of them are directors of the company. 3, my lords, are outsiders.
Okay.
But they're family members, my lord.
Right.
The reason, my lord, is that since directors are being paid salary,
correct,
they should not be getting commission, my lords.
Correct.
My humble contention, my lord, is it has been noted by the assessing authority that I have deducted TDS on the for the commission paid, my lords. All these persons, my lord, they have filed their returns and they're paid due taxes, my lords. So again, adding this commission to my lord, the profits and income, my lords, would amount to double taxation, my lords. And number 2, my lords, so far as section 37 is concerned, my lords, in my humble submission, it is not applicable to the facts of the present case, my lords. If your lordship would kindly come to the assessment order, my lords, at page 33, my lords. Assessment order is annexure 1, page 33.
Right.
Just a few lines above paragraph 4.4, my lords.
Right.
Another argument, your lordship, about it?
Yes.
Of the SSC was that this commission payment has been subjected to TDS under section 194H, and the commission earned has been disclosed by the recipients in their respective return of income. This argument of the SSC is not acceptable for the reason that the income has to be taxed in the hands of the real person who has earned it. Because my humble contention, Lord, this will amount to double taxation. I have deducted TDS.
And this has been disclosed in the individual
returns. Return. They have paid taxes.
All right. We just say notice. Mr. Satpathy is there?
This is Ramuna District Balasur. I think Mr. Mahapatra is appearing for this Balasur area first.
Mr. Mahapatra, are you there?
Well, I will instruct you, Lordship.
All right.
I'll serve a copy.
Admit.
Balasur belongs to me.
All right.
I'm sorry.
Chimanka.
I'm sorry. I didn't know about it. No. I thought it was Mr. Mahapatra. I'm sorry, Mr. Chimanka. No.
Yes, yes. Balasur area belongs to me.
All right.
And copy is not copy in the kind.
Yeah. The following question of law is a frame for consideration. Whether the CITA, whether the assessing officer bracket AO, the CITA and the ITAT were right in disallowing commission expenses and in applying section 37 of the Act. Question mark. You say, since Mr. Chimanka has accepted notice of admission of the appeal, additional copies be served on him.
May I humbly just pray?
Yeah.
Especially the fact that TDS has been deducted and
No, those are grounds.
much.
12th May.
Supplementary
There's
list
a
item number
miscase
8.
for dispensing filing of annexures 2 and 3.
Right, that's allowed already.
So the defect number 5 is removed. Note that maybe
That's right.
and
That's
there's a stay, my lord, your lordship.
stage is notice on stage.
Much. Greatly obliged.
All right.
Item number 8.
Item 8, 1 week may be granted for removing the defect number
All
6 and 9.
Defects be removed within a week. List thereafter.
Obliged.
Supplementary item 9. Item number 9.
Case double for 7.
That's right. That's right.
Sorry, my lord. My item is 9. Sorry, my lord.
Oh,
Sorry, my lord.
so you were mentioning the wrong item.
Sorry, my
So
lord.
who's in 9? Who's in 8? Sorry. Siddharth Samal.
9 is my item.
All right.
Sorry,
8
wrong.
will pass over. 9, you say defects be removed within a week. List thereafter. All right.
Sorry, my lord.
Not problem.
Supplementary for admission item number 10.
None appears dismissal. No possible.
Item number 11.
This is the case with regard to declaring Orissa as a dry state. And as per its last order, a compliance affidavit has been filed. But
Right.
as far as my knowledge goes, your lordship wanted to know whether
Yes.
the Prohibition Act 1956 has
Correct.
been implemented or not. Now,
Correct.
as far as the compliance affidavit is concerned, they
Yes.
say anything about whether this act is in whether the act has been implemented or not. They simply say that this court has got no power to issue a direction or by way of a writ of mandamus. So let them first clarify as to whether this act has come into force or not.
Yes, Mr. Monty.
We'll file an affidavit to that.
You can't. The answer is obvious. Too obvious.
Total prohibition he wants in.
Not he wants. He says there is a
That is
statute.
a
Are you
statute.
serious about the statute?
And that I have replied in my counter affidavit. If is any specific query is there, your lordship may direct me. I will.
No. It's a very simple thing. He says you have a prohibition act. He says, are you serious about it? Are you implementing it?
Exactly.
Either have the act or don't have the act. You can't have a prohibition act and then have a policy of off shops, on shops.
We will file affidavit.
You say on the issue whether the state is serious about the Orissa Prohibition Act, senior counsel, the petitioner, insists that the state must come clean on its stand on whether it is serious about its implementation. Mr. Mohanty states a further affidavit will be filed by the state in this regard, specific to this issue, at least 1 week prior to this next date, with an advance copy to counsel for the petitioner. We'll have it soon after the break. 29th June.
29th June. Obliged.
All right.
Item number 12. Supplementary list item number 12.
None appears dismissal, not opposition.
Item number 13.
None appears dismissal, not opposition.
Item number 14.
I'm appearing for ITCO, my lord.
All right.
I am for
None
OP
appears.
number 11, my lord.
Sorry?
I am for OP number 11.
All right. None appears dismissal, not opposition.
Item number 15.
Sorry, my lord, item 13, it has become item 13, my lord.
Item 13.
It has become infructuous.
All right. 13, you just note down. Counsel, the petitioner states the petition has been rendered infructuous. It is disposed of as such.
Item number 15.
Item 15, my lord. The petitioner's block and the farmers has been obtained loans under the National Agriculture Insurance Scheme, which has been implemented by the state government as under Annexure 1, my lord. And the nearest adjacent block has been granted the insurance amount, my lord. Whereas
Even yesterday we had a similar case.
Yes, my lord.
Do you have names of specific farmers who have been denied insurance claims? Any specific instances do you have? What is happening is you come across a newspaper clipping and you say, let us make a PIL out of it. So immediately enclose the newspaper clipping, have an affidavit, file a PIL.
I am on the capacity of Krishak organization.
No, all that is fine, sir. So if you are a grassroots organization, you should be able to tell us some specific instances of farmers who've been denied these claims. Some additional homework has to be done. See, this is what I call a lazy PIL. You read a news item in the paper, enclose it.
I belongs to Polosara block.
Maybe.
And that has been affected in the year 2015-16.
Anyway, so today we are in 2022.
Well, that is since that pending, and I have complied all the direction of the court, my lord.
What? No effort was made to have it this listed, but that's not the end of the problem.
My lord, I am the petitioner. I am the affected. We are the affected persons, and
no persons. There is a single petitioner. All right. You are president of the Nangleshwar Krishika Sangha.
Sangha,
right? Krishaka Sangha. I'm only asking you, can you even give us names of, let us say, 50 farmers, even not 100, sampling? Give us, this is how many tehsils does it cover? This is Polosara tehsil. How many tehsils are affected? According to you, how many tehsils are affected?
Almost all, my lord.
This is the whole problem, sir. Once you say almost all, then implementation becomes difficult.
In that year, the drought affected area that.
So you have to find out some actual individuals. What happens is, otherwise you have false claims. They will say, no, we have paid everyone. You will say nobody's been paid.
Poor farmers, my lord.
Everybody is poor. There's no difficulty, sir. But let us have names of poor farmers.
Next, your lordship, 1 week time may be granted. I will submit the persons who have been affected.
In the meantime, my lord, we have obtained instruction, my lord. These petitioners, they belong to Polosara block, my lord. We have taken instruction basing upon the threshold yield and actual yield, my lord. No Gram Panchayat under Polosara block has been found to be having shortfall in.
See, this is the point. Exactly the point I'm making. Yes. So the minute you simply say everybody is affected and they say nobody is affected,
that counter they have not.
That it will not serve your purpose. That counter is going to say nobody in Polosara block is affected.
Let me
you pick up names from Polosara block. Give us names of at least 5 farmers, 10 farmers,
next
20 farmers.
Within 7 days, I will submit the names.
Among the grievances made in the present petition, which is in the form of a public interest litigation, is that farmers belonging to the Polosara tehsil. Which district is this? Ganjam district. Have not been paid. This is crop loss insurance.
Yes,
the crop loss insurance amounts. The court would like the petitioner to place in the form of an affidavit the names of at least 20 such farmers of Polosara tehsil who, according to the petitioner, have not been paid the crop loss insurance. The affidavit will be filed at least 1 week prior to the next date with an advance copy to counsel for the state, who will then obtain instructions
with regard to those 20
specific to those names. List on 5th July. Okay. There's sufficient time now for you. 5th July.
Yes, ma'am.
All right.
Item number 16.
It may please your lordships. While the sole question before this honor court to adjudicate in this PL that as to whether the Anganwadi center shall be constructed by departmentally or through police Sabha, my lord. Well, here the Dasipur additional construction of the Anganwadi building of
So
the
by now,
additional Anganwadi
there is no
center.
interim order here, sir.
Interim order is there, my lord. That was
Is there?
Yes.
So you stopped an Anganwadi center from coming up?
No, my lord. What is there? The statute provides.
If there is an interim order, then obviously you stopped it.
10/12/2018, the interim order has passed.
1 minute, let us just see that. Status quo. So why do you get status quo for an Anganwadi center? Yes. That helps children?
My lord, the question is, my lord, they are doing it departmentally, which is to be done by the police Sabha, my lord. So losses will come to page 13, my lord. I am taking.
These are all proactive welfare measures, correct?
So it is under Monrega, my lord. Your losses will come to page 13. I am taking your loss to page 13, my lord.
All right.
The page 13, my lord, Monrega.
Right.
The Mahatma Gandhi National Rural Employment Guarantee Act 2005 aims to provide the unskilled manual work to any rural household on demand and employing them on construction of the
Anganwadi center is a notified activity, correct?
Notified activity, and statute section 16 minor Monrega comes under that. The Anganwadi center comes under Monrega under Annex 3, page 19, my lord.
All right.
Out of 7 lakhs, 5 lakhs is under the Monrega, 2 lakhs is to be booked under funds of Women and Child Development Department. Right. The losses can come to section 16 of Monrega.
You've set it out in the petition?
Section 16, my lord.
No, have you set it out in the petition?
Yes, my lord. In the ground, I have taken. I have taken the ground.
No. You haven't set out the provision. Anyway, make your point, sir. What is it? Section 16 says what?
The Gram Panchayat shall be responsible for identification of projects in the Gram Panchayat area to be taken up under the scheme as per the recommendation of the Gram Sabha and Ward Sabha, and for executing and supervising such works.
All right. So what is your objection?
Therefore, as the construction of Anganwadi center under Monrega project, it is to be done by the police Sabha.
No. Who's doing it? According to who's doing it? According to
department DPT, Gram Panchayat.
So what is the prejudice cost? Well,
they are not constructing it properly. If it is constructed,
what is properly meaning what?
Their substandard construction they have done.
That is a very different issue. Why do you stop the whole construction?
Well, that as statute provides, the construction is to be done by the.
No. What is the prejudice if the construction is done by another state agency and not the Gram Sabha? What is the prejudice?
Gram Sabha, Police Sabha. Police Sabha is to choose who will construct that building among them, my lord.
Sir, we are still not able to understand what is the prejudice cost.
Prejudice, the villagers presumes that construction one building was constructed that was substandard. They presume that if this building will be constructed,
quality of construction is one issue that can be addressed separately.
We have given that representation that referred to the collector previously that construction of previous building was substandard and the water is leaking within 2 years.
Sir, if your grievance is only about the quality of construction, that can be addressed.
Yes,
why do you stop the construction? But
my lord, let police
why should children in that area be deprived of this Anganwadi center?
No, we don't want, my lord. Now? There is an Anganwadi center in that village. It is an additional Anganwadi center. Therefore, we pray that the construction of the building shall be done by the police as per the statute, my lord.
The original Anganwadi center is operating since 2012-13, my lord.
All right.
This is an additional Anganwadi center which has been constructed up to the window level, my lord. But due to the agitation of the local villagers, the construction has been stopped in the meantime. And as after the grievances were made, my lord, field verification was made. Inquiry report has been submitted, wherein it has been mentioned that the preschool, pre-minor school, and minor children, they are coming to school. The education system is going on well, and the quality of construction of the building is also all right, my lord.
It's all right.
If my learned senior
first building,
not second. I'm saying about second building. No, second building. Yes. The additional Anganwadi center, my lord. And if your senior has difficulty with regard to quality of construction, my lord, Lordship may say
that has not been constructed. Status quo has been active since 2008.
No.
Obviously, there was some construction already undertaken. Must have stopped because of the order.
It was on up to 10th level. Up to plinth level, the construction was done.
Whatever, let it go on now, sir. Let it go on now. We can have representatives of the Gram Sabha.
Yes.
You form a committee.
Yes.
Let some representatives of the Gram Sabha be there in that committee for supervising the work of construction.
My lord.
And you ensure that the quality doesn't deteriorate. That is,
Yes, your
that should take
lordship
care of your.
that, my lord.
All right.
Your
all
lordship
right.
that.
All right.
Yes,
The grievance
your
in the present petition is that the additional Anganwadi center of village
Kasipur
in
all
Owl block, owl.
all block.
in district Kendrapada, in Rajkanika and district Kendrapada.
Well, it is under all block, not Rajkot.
All, okay.
All, AUL.
AUL in district Kendrapada.
All. Popular name is Ali, but in the
Ali,
English pronunciation is all.
All, correct. Is of poor quality and is also not in conformity with section 16 of the Manrega Act, which requires such construction to be undertaken with the approval of the Palli Sabha of the Gram Panchayat. Paragraph. While this petition was admitted on 10th December 2018, an interim order was passed asking status quo to be maintained in respect of the construction of the additional Anganwadi center. Paragraph. Having heard learned counsel for the parties, the court is of the view that the additional Anganwadi center is meant to serve the children in the area, and stopping the construction is of no constructive purpose for anyone. If the concern is about the quality of construction, that can easily be tackled by involving representatives of the Palli Sabha in the work of supervision of the construction. Paragraph. Accordingly, it is directed that the collector, Kendrapada, will constitute a committee which will have representatives of the Palli Sabha of the village in question in order to supervise the completion of construction of the additional Anganwadi center. The purpose, one of the main purposes of this committee would be to ensure that the quality of the construction is of acceptable levels. This be completed, the committee shall be constituted not later than April 2022, and the work of completion of construction, the construction of the additional Anganwadi center will be taken up forthwith and completed within a period of 6 months.
A reasonable period, because other hindrances might be there.
All right, within a period of 6 months thereafter. The interim order is accordingly vacated. The petition is disposed of.
Only add the local block development officer may kindly be made a part of that committee.
No, that's right. You say it will be for the collector to involve the other representatives of the local administration in the committee. Right.
Item number 17.
None appears to dismiss from opposition.
Item number 18.
May I please, your lordship? May I please, your lordship?
Yes, please.
But I have challenged in the form of PIL, my lord, that the creation of a sand violating the guidelines, my lord, framed by the state government under Annex 2.
So this is 2019 petition, correct?
Yes, your lordship.
Now the period of this is a 5-year lease, or?
No, it is not lease. Creation of that sand in contravention to this provision.
No, creation must have been followed by some tender notice.
Followed that is postponed as per the affidavit filed by the state government. Your lordship, I may be permitted to read the para 7 of the counter filed by the Tahsildar Opinor 4. Your lordship,
permit me to read this that he has responded your lordship.
All right.
Para 7.
All right.
That it is respectfully submitted that the objection petition filed by Sarpanch of Purohitpur Gram Panchayat and others was heard on 31st-10/2019 in presence of the objectors. The Sarpanch along with the committee members made objection regarding possibility of creation of leaking point in the river embankment due to plying of sand loaded vehicle over it. If the source will be leased out, further they stated that there was one leaking point, my lord, that is Ghalia, that in Odia, that is leaking point in the river.
Let's postpone. Let me ask Mr. Wanti. So what is the present position?
The next paragraph is important at page 4. They have applied for mining clearance and Director of Geology Consultant Private Limited, Cuttack Road, Bhubaneswar has requested to submit approved mining plan of the source via this office letter number so and so. However, after receipt of the report for the technical personal action has been
So it has been postponed. It says
no advertisement has yet been issued.
No. What is therefore, as a policy decision, you're not going to go ahead with this?
No, we are going ahead, but there is no final decision as it appears from. Then current status, because it is the counter affidavit was filed.
So you file a further affidavit? Let us know what has
current
happened.
status. Yes,
all right. As per the counter affidavit filed on 29th November 2019, in view of the objections raised to the creation of the sand Sairat source, the authorities had considered it prudent to not proceed with the auction sale notice at that point in time, awaiting the technical feasibility report. Full stop. Mr. D.K. Mohanty, learned additional government advocate, states that he will file a further affidavit to inform the court about the current status.
Yes.
The affidavit be filed at least 2 weeks prior to the next date with an advance copy to consider the petition. Again, this will have it after the vacations. 30th June, 30.
30th June.
Supplementary is item number 19.
I'm the intervener, Miller. This is not a public interest litigation, rather it's a private.
All right. Anyway, there's no one appearing. None appears dismissal, non-opposition. Today. All right. Yes.
Passed over matter item number 8.
Dismiss.
Supplementary list item 8.
None appears dismissal, non-opposition.
Hearing item number 21.
This was that part heard yesterday's.
May I please, your lordship?
Yes.
Miller, in criminal appeal 338 of 2004, Miller.
Right.
I am appearing only for Srimati Shanti Parida and Sudarshan Parida. For Prasanta Parida, other advocates are appearing.
All right. So we'll do one thing. We'll just take it at the end of the board, sir. Kindly wait on. We'll take it at the end of the board. We'll just run through the list. There's nothing else. All right. Carry on. All right. Carry on, sir.
Obliging. So, lordship may kindly want to.
No, you haven't told us why we should not believe PW 21.
Miller. Before that, I am. Lordship may kindly come to the page 33, para 28, Miller. Para 28 says exhibit 26, which is said to be dying declaration of the deceased Mana, does not appear credible, but the evidence of Devendra PW1, Surendra PW7, who is the hostile witness, Miller, Vinaya PW21, Bina PW24 is trustworthy. The deposition of PW20, he is also a hostile witness and daughter of the deceased, Miller. Monisha, in maintenance suit by her mother against her father is credible.
he has discussed a deposition in maintenance case, my lord. Here, which shall be given greater importance as against her evidence in court. Therefore, I'm on that day I'm deposing that he relied upon P1, P7, P21, P24, my lord, and P20. First, I like to come to my lord P1. My lord, P1 at page 80, my lord. He has stated, my lord, he is sorcerer and he has stated, I along with said Khogeshwar and accused Babuna went to Calcutta to the house of accused Sudarsana. On that day at about 2 p.m., accused Babua disclosed me regarding the purpose of inviting us to Calcutta and thereby requested me to kill his sister-in-law by witchcraft. But in cross-examination, he has stated, I had no prior acquaintance with the accused Babua. In cross-examination starts from next page, my lord, para 2. I know a little witchcraft. As admitting, I have not killed anybody by practicing witchcraft. And our villagers know that I cannot kill anybody by witchcraft. Therefore, in these circumstances, even a common man cannot spend money on this person to take Calcutta and to finish the disease by witchcraft. It is a very absurd story, my lord. He himself is admitting I have never not killed anybody by practicing witchcraft, and no everybody knows that I cannot kill anybody by witchcraft. This story has been created later. I will come to later, my lord. Thereafter, my lord, your lordship was referring P21, my lord.
See, the mother's evidence is against you. There's no mother. You've not made any comment on her evidence. Why we should disbelieve her? You've not made any comment on PW21. You'll have to, sir. You'll have to deal with evidence that is against you. Correct?
I'm coming. I am coming. That has been subsequently how that has been subsequently created. I will prove, my lord, before your lordship. The first FIR has been, my lord, suppressed. And dying declaration recorded by a Tahsildar that has been suppressed, and IO has admitted in his evidence at para 24. Page 125, my lord, is the evidence of IO.
22, sir.
22, sir. My case diary reveals that, as learned by me, dying declaration of the statement of Mana was recorded by Tahsildar at District Headquarters Hospital, Bhadra. I have mentioned that fact in case diary on dated 16/3/19.
Suppression going to help you, sir?
One dying declaration has been recorded by the IO Miller in form of 161 statement that has come to the record.
No, unless there is something according to you, let's say instead of naming you, he's named X. Then you can take advantage of this.
That is not record. He might have
No,
not have stated
since
against
nobody knows what the Tahsildar recorded, how is it going to benefit you?
Miller, in criminal case, prosecution has to prove its case beyond all reasonable doubt.
Exactly.
But
There's
it
no
creates doubt.
difficulty on that. There's no difficulty on that.
This point, Miller, creates doubt, Miller, why this has not come to record. He might not have stated against the petitioners, Miller.
That's what all of this is surmise, right? That he might not have. See, he has actually made a declaration before PW 23, PW 21.
21.
He has actually said one of the persons who attacked me had a squint eye.
Yeah.
He's given both the names, Bayana and Babu.
My lord.
So he's given both the names.
I have been implicated. We have been implicated. Santi and Sudarshan only abatement. They have not come to the spot. Nothing. Only they have dragged us, Miller, 109 through 109, Miller.
All right. What else, sir?
I'm coming, Miller.
Can we hear the counsel for the other accused?
Kindly see at page 83.
Right. 83.
The informant has turned hostile, but he has stated.
So the informant is only a Gram Rakhi. Correct?
Yes, ma'am.
Miller.
The informant.
Miller Gram Rakhi.
Ha.
I'm reading, madam. I am the informant in this case. The occurrence took place about 2.5 years back. On that day at about 9:30 p.m. when I was in my house, Damborodhara Jena, the brother of the Sarpanch, requested me to come to his house, saying that one unknown Bengali youth was lying injured near their house. Then I accompanied him to their house and found that the injured person was lying in front of their house. He was complaining of severe pain and his language was not understood by us. At that time, some people gathered there, disclosed that the sister of that injured was also lying dead at some other place. Due to telephonic disturbance, the Sarpanch Binoy Kumar Jena, having failed to contact the local police over phone, took me in his two-wheeler to TDPS. By that time, the OIC and his staff had already left for the spot on getting information. This means, Miller, he had earlier information was there. First FIR has been suppressed, Miller. Thereafter, Miller, but the alleged occurrence from some other source, then we turn to our village.
All right.
On third day of the death of Bengali youth, on being called by the OIC, I had simply signed in written document.
All right.
After 3 days, his signature has been taken on a FIR, Miller. After 72 hours,
Yes, sir. Yes.
After 72 hours, Miller, this signature has been taken. Also, after 72 hours, FIR has been sent to London Magistrate.
Mr. Das, you're in appeal, all right?
Miller.
In an appeal, you have to deal with what is against. You have to deal with what is against you. There's no point in only reading what is in your favor. There is so much which is against you. If you don't deal with it, how do you succeed in your appeal?
I'm dealing one after I'm showing your lordship that
you're showing everything which according to you is in your favor. You're not coming to what is against you.
Miller, I am showing that subsequently how case has been developed, Miller. Behind back, Miller, first FIR has been suppressed. Dying declaration recorded by a Tahsildar has been suppressed, not to come to the record. But prosecution has not come to the court in clean hand matter.
Anyway, all right.
Thereafter, Miller. PW 21, I like to the evidence of take to the evidence of PW 21, Miller, at page 64.
Yes, sir.
Sir.
Where do you want to read?
No, coming.
It's very short, sir. There are only 4 paragraphs.
Miller.
Five paragraphs.
Miller. Short. Page 105.
Yes, Mr.
Sorry, Millard, at page 105.
Which paragraph do you want to read, sir?
I'm reading on from first paragraph, Millard.
All right. I knew the accused persons. All right.
Accused person and both the DC.
Why don't you make yesterday we've read the whole thing. Why don't you make your proposition? We've read the whole evidence yesterday, sir.
Yeah, I'm not reading whole, Millard. I'm just one line.
Why don't you make your proposition? What is it that you want to argue?
Millard, in chief examination, he has stated, I came to our Bari side. Bari means Odia, Bari means Millard, backside of his house.
All right.
I came to our Bari side and found deceased Munapal coming in a bleeding condition.
Right.
But in cross-examination, he has admitted, Millard, I had stated before the police that one person came and fell in front of our house.
All right. Okay. So, okay.
Millard, a natural witness cannot commit such type of, Millard, that he will say in front and backside he will commit that type of mistake.
All right.
This is a material contradiction.
Isn't the crucial thing about the man coming in an injured condition and falling there? Isn't that the crucial thing?
I do concede, Miller, but a common man cannot commit this type of mistake front side and back side.
When was he being examined and cross-examined? How many years afterwards?
Let's
see the date. Let's see the date.
2004. And the Miller
2004. 2004. This incident happened in 99.
4.5 years back.
If you ask me what I ate day before yesterday, I won't know. Mr. Das, now you have to hurry up.
Millard,
this is the second day of argument.
Millard, the London Trial Court in Para 23 had discussed, Millard. Another complaint is that the statement does not disclose on which day the magistrate has received the same. The statement was not previously. On 16th, the Baina has been sent to the magistrate having jurisdiction along with a forwarding report on 23/99. Along with the forwarding report, the statement of PW 21 has not been sent through, though two other statements have been made available to the court, Miller. It is submitted that the statement of Bina Jena PW 21 has not existed till forwarding of the accused Bina, and it has been created afterwards. The IO has categorically stated and his investigation has disclosed regarding the statement of on 16/3/99, that is before forwarding of accused person. The statement does not disclose on which date the magistrate has received the same, Miller. The last line he has mentioned. Now the question is what adverse effect would be deduced from the absence of the initial of the empowered magistrate over a statement recorded under section 161 CRPC.
Right.
He has admitted that though no initial was there on the 161, that is created in a later, Mirror. to suit the prosecution, they have created everything, Milord. They're on record.
All right.
Also, regarding FIR, I am showing Milord at page 24. I am showing Milord. Lordship, may kindly come to the page 24. And
Yes.
9th line from the bottom.
Right.
The R1 register, Exhibit B, shows receipt of the FIR along the concerned order sheet on 19/3/99. The informant receipt of the FIR is showing that the receipt of the FIR has been received on 19/3/99. Occurrence has on 15/3/99 night. They are saying that 16/3 registered on 63, but the register shows FIR has been received by the master on 19/3/99. Milord.
All right.
And thereafter, Milord, Lordship, kindly come to the page 29. What he has, Milord, stated regarding this Land Trial Court. And relied on a judgment, Milord, also. At page 28, para 22, Land Trial Court has relied on a judgment as regards delay of 72 hours in submitting the FIR before the magistrate is considered appropriate to refer AR 1970 Supreme Court. He has referred State of Punjab, Section 157 CRPC requires such report to be sent forthwith by the police officer concerned to a magistrate empowered to take cognizance of such offence. This is really designed to keep the magistrate informed of the investigation of such cognizable offence so as to be able to control the investigation and if necessary to give appropriate direction under Section 159. But when you find in this case that the FIR was actually recorded without delay and the investigation started on the basis of that FIR and there is no other infirmities brought to our notice, Milord. In this case, what happened? There is no other infirmities. He has relied this judgment, but here dying declaration by the Tahsilar has been suppressed, FIR has been delayed, subsequent FIR has been created, Milord, and he has stated next page, very next page, he has concluded they have not stated in what manner delayed submission of FIR before the magistrate cause prejudice to the accused person. Prosecution has to stand on its own leg, Milord. He has to prove its case beyond all reasonable doubt. Not that the lacuna of the accused person, you will take the benefit, Milord. I have also relying on a decision, Milord, reported in 2007 38 OCR Supreme Court. Here it has been mentioned that Section 57 of the Code Criminal Procedure mandate that the first information should be sent to the nearest magistrate within a period of 24 hours. In the present case, it was done after 4 days without any explanation for delay. Here also no explanation has been given, Milord, by the prosecution how the 4 days has been delayed.
No, if there was any delay,
Milord,
and there has been no explanation offered,
Milord,
how it has prejudiced the accused. That is one of the aspects to be considered, no?
Milord. Reduced like this, Milord, they can tamper the.
Who's going to gain by such tampering, sir? All of you accused are from Bengal, correct?
I am showing evidence from their evidence.
Registered in Badrak, correct?
Informant is, Milord, their witness, not our. He has stated that before
there
going
must be.
to the police
See, all these things will attain significance if you develop a theory of some previous enmity where people want to deliberately implicate you falsely in a case. That's not nobody's case. These are all complete strangers to you. You're from Bengal. This is happening in Badrak. These are local people in Badrak. Whether it's the informant or this PW21, they're all completely local people who don't know you from before. Why should they falsely implicate you, sir?
Milord said, I know that accused has taken a plea in the 313 statement that he has rivalry with the PW21, who is the Sarpanch, local sarpanch and a political man, my lord.
No. Who's got rivalry? It's a shot in the dark. How can you have rivalry with somebody in Bhadrak?
He has been examined at DW1, my lord.
My lord.
1 minute. Sir, have you finished? Mr. Das, are you done?
Some points are there, my lord.
All right. Tell us, sir.
My lord. Miller PW24, he has stated that I cannot say the date when Babua told Rita that Sudarsana marriage Shanti and marriage document would be available in Orissa. Further, he has stated at page 133 that I cannot say the date when I asked my son Manapal to accompany Rita. At page 134, Miller, he has stated PW24 categorical stated from Bapi. Bapi is the son of deceased Miller. Bapi and Monisha. Monisha is the daughter of deceased at turned hostile PW20 Miller. I learned that Rita, Mana and accused Babua left Hyde Road residence of the Rita Pal in a bus to come to the Orissa. It is the hearsay evidence that he has stated he had.
The mother is very clear about this going to Orissa. She has stood very firm. The mother's evidence is very clear, sir.
Miller. He has stated regarding the Bapi Millard. He has not stated regarding Millard, the Sudarsana and Shanti Millard. Sudarsana and Shanti has been implicated by the evidence of PW1, connecting the evidence of Millard PW1, who is a sorcerer. He stated that he has brought to the Calcutta to finish him by sorcering Millard. Only by PW1, evidence of a PW1, they are dragged Millard, Sudarsana and Shanti Millard.
All right.
Apart from that, Millard, no weapon have been seized, Millard. Bio has not seized any weapon, Millard. And Millard, relying on decision on 2016 Supreme Court 2 OLR 755, Millard.
1 minute. Tell us the citation. 2016.
Millard. 2016
2 OLR
755 Millard.
What is the cause title, sir?
Gedu alias Parameswar Patra versus State of Orissa, Millard. Here, Millard, it has been decided, Millard, in a case of based on circumstantial evidence, motives, absence, surmises, pertinent significance, as existence of the motive is an elegant factor in a process of reasoning of such the circumstances more carefully to ensure that suspicion and conjecture do not take place of legal proof, Millard. And in criminal trial, suspicion, however strong or emotional consideration, cannot take place of proof. Fouler the crime, the higher should be the proof, Millard.
All right. Let us now hear the counsel for the other accused, sir.
Millard.
All right.
Ma'am, please, Lord. My lord, this incident took place on 15th March.
No, you are appearing for, sir?
I am appearing for Vaidhar Mahik, alias Baina, my lord, in General Appeal number 50 by 2005.
Right.
My lord, this incident took place, my lord, in the year 99 March. Date, my lord, 14-15 night, my lord. My lord,
Baina is the person with the squint in the eye.
Yes, my lord.
Ah.
Yes, ma'am. My lord, the learned trial court relied on the statement of Devendra, PW1, my lord, Suresh, PW7, Bina, PW21, and Bina. Bina is the mother of deceased Rita Pal.
She is PW?
24, my lord.
24.
My lord. My lord, for a while, let us rest, my lord, the statement of Bina, my lord. I will come to that part later on, my lord. if we will keep it rest, my lord, the statement of Bina, my lord, PW 21, then it is purely a case of circumstantial evidence, my lord. And the chain is to be completed fully, my lord.
Correct.
Because, my lord, there is a quotation, my lord. Circumstantial evidence is a very tricky thing. It may seem to point very straight to one thing, but if you shift your own point of view a little, you may find it pointing to an equally uncompromising manner to something entirely different, my lord.
I see.
Yes, my lord.
What is here entirely different? What is your alternative explanation?
Yes, my lord, I am going to that. My lord, this incident took place on 15/3/1999, and this accused Baina, he was arrested on 19th, my lord. 19th March, my lord, immediately after 3 days, my lord, by the IO. And IO recovered the wearing apparel of...
Where were you arrested from, sir?
My lord, from the village, my lord.
Where?
So I have not left the village, my lord.
All right. From village, where in Bengal?
My lord, all these accused persons, my lord, appellants, hails from Tihidi, my lord.
Tihidi?
Remote area of Tihidi in the district of Bhadrak. And the deceased were from West Bengal, my lord, Calcutta. Accused persons are all Odia, my lord.
Not the first two accused are not Orissa, sir. My husband and wife are not. Husband and that second wife
all
are not
Odia, my lord. Accused Sudarshana, he was serving
and
in
Shanti,
railway.
both Sudarshana are Bengalis.
No, my lord. He is Odia, my lord.
But
he is Odia, my lord. He belongs to the same village where this Baina, Babu, and Shanti hails, my lord. Same village. Shanti and Sudarshan were related as sister-in-law, brother-in-law.
Shanti was previously married to Suresh, my lord, PW7.
Married to PW7, my lord.
They were separated and then
they are separated.
married this present appellant.
No, but where did this Bengali angle come then? If all are Orias?
Bengal angle came because they shifted to Bengal for his work purpose.
So they were in Bengal.
Yes.
They were in
correct.
This is Rita was the Bengali. This is Rita was the Bengali.
Sudarshan married to Rita.
So both the deceased are Bengalis.
All the deceased are Bengali.
Miller. The both deceased are the Bengali.
These persons are Odia, my lord. Sudarshan married to Rita in the year 7980, my lord. Subsequently, there is marriage disturbance due to his love intimacy towards Shanti as alleged by the prosecution, my lord. And this is the motive what is assigned in this case, my lord, for commission of this offense, my lord. And he used Babua and this Baina as accomplice for commission of the offense, my lord. That is the my lord whole story, my lord. Now, my lord, this appellant Babua, he was Baidhur Malik alias Boina. My lord, he is of squint eyes, my lord. He was arrested 3 days after on 19 March
from
2019, but no weapon was recovered, my lord. He was arrested from the village, my lord, while he was farming, and the wearing apparels, nail clippings were seized, my lord. Only thing is that
the blood on your wearing apparel perfectly matched the blood group of Rita,
the victim.
My lord, that B group blood, my lord, that matched, but my blood group was not taken, my lord.
There's no need, sir. Why should your blood? You are not injured.
My lord, that part is silent, my lord.
What is silent? Sir, you develop that theory if you are injured.
My lord, that part is not...
how is it relevant? If you're not an injured person, how is it relevant whether your blood group is taken or not? This is not some rape case. You have to explain how did Rita's blood come on your wearing apparel. It is up to you now to explain.
My lord, then Boina's blood group was not taken, my lord. So, yes, my lord.
You are repeating the same thing. Anyway, all right.
Yes, but that part is absent, my lord. My lord.
What is your explanation? How did this blood, Rita's blood come on your wearing apparel? What is your explanation?
My lord, my explanation is that there was, from the defense evidence, my lord, given by Baina himself, nothing was seized, my lord. No apparel was seized, my lord. and no independent witness has supported, my lord.
All right. All right. So no independent witness for seizure.
Yes, ma'am.
All right.
No independent witness.
Seizure
What is the law
witnesses
on
are
that,
not
sir?
suitable.
What is the law on that?
And my lord, let us, my lord, examine the statement of PW 21, Bina, my lord.
All right.
His statement is most vital, my lord.
Correct.
My lord, on the last line, cross-examination at page 5, my lord.
Munapal, while sitting in our body, told us that Babu and Baina assaulted them, correct? That line, end of para 1.
End of para.
Munapal, while sitting.
My lord, at page 106, my lord.
All right, you've gone to the next page. Okay.
Yes, yes, ma'am.
All right.
Last para, ma'am. Para 5. My lord, in the cross-examination, may I read, my lord?
Yes.
I do not remember if I had not stated before police that Munapal asked me to rescue his sister. It is not a fact that I had stated before the police that all conversation with Munapal began after Gramarokhi arrived. It is not a fact that I am deposing falsehood due to political rivalry. That was stated, my lord. But not more than that, my lord. Nothing else was there. But in the defense evidence, my lord, D1 statement, my lord, at page 78. May I read, my lord?
Yes.
I am an accused in this case. My house situates at Mahalik Sahi of village Bilona, Noyapatna.
DW1 is yourself?
My lord.
Okay.
My lord. It is within same panchayat, that is Bilona Gram Panchayat. In 1999, Dhiren Naik was Sarpanch of Bilona Gram Panchayat. He was a candidate sponsored by Janta Dal. I was his supporter. By saying Janta Dal, I mean BJD, Biju Janta Dal. The adjacent Gram Panchayat is called Tolapada Gram Panchayat. My lord, Tolapada Gram Panchayat, the Sarpanch of Tolapada Gram Panchayat was, my lord, PW21, my lord.
All right.
In 1999, Bino Jena was Sarpanch of Tolapada Gram Panchayat. Bino Jena is a member of Congress party. I had political rivalry against Bino Jena. The population of our village is about 10,000. The rest is not relevant, my lord. So there he has deposed that there is a political rivalry between both the parties, my lord. And in the cross-examination, that has not been contradicted by the prosecution, my lord.
All right.
That is not there, my lord. Second, my lord, is the statement of PW1, my lord. The sorcerer. My lord, he has stated in his deposition in chief, my lord, that he proceeded to Calcutta along with Babua, but he has not stated that whether I accompanied him or not. But in the 164 statement before magistrate, my lord, which is, my lord, exhibited, there is, my lord, in Orissa.
This is 164 statement of which PW?
PW1, my lord.
PW1.
Devendra Mal.
Clinic was rejected. Consequently, I was rejected. I never applied.
That is, my lord, exhibit 22, my lord. That is the 164 statement of.
Therefore, to clarify your notice, there may be a thought. The doctor is not the applicant per se, so far as the registration is concerned.
Yes.
My lord. But in the 164 statement, he has stated that I, along with Babua and one Khogeshwara, they accompanied all to Calcutta. There, they requested this witness for sorcery in order to kill Rita Pal. But in subsequently, in his deposition, he has not stated that whether I accompanied or not.
All right.
Nowhere is there, my lord.
All right.
Shall I read, my lord, the relevant person? On the next day, one Khogeshwar Mahalik came to my house to call me 3 times and insisted me to go to Calcutta. Then they insisted my mother to allow me to accompany them to Calcutta, to which she did not agree. However, after much persuasion by them, I agreed to go to Calcutta. I, along with said Khogeshwar and accused Babua, went to Calcutta to the house of Sudarshan Malik. That is the statement, my lord. So I was not there, my lord.
All right.
I'll not bother your lordship with the evidences of all the witnesses because since last 2 days, my learned seniors have been placing that, my lord. The prosecution is relying upon PW 1, 7, 21, and 24. My lord, one is Devendra Malik, who is the sorcerer who was asked to go to Calcutta, accompany there, and there he denied to help the accused person in killing the victim, my lord. That evidence is there. PW 1 is Devendra Malik. PW 7 is Suresh Parida. He is the husband, first husband of the, my lord, the appellant number 1, Shanti. PW 24, she is the mother of the deceased, my lord. She has fully corroborated the fact. She supported the prosecution story with regard to the incident that has taken place. And PW 21 is the post-occurrence witness before whom the deceased had last told about, directed the incident, my lord. These are the 4 prosecution witnesses, my lord. As far as, my lord, the dying declaration is concerned, Lordship may kindly see page 25, para 17. Here it has been recorded by the learned trial court, my lord. The investigating officer has stated that he has recorded a true version of deceased Manapal when he was under treatment by Exhibit 26. The statement discloses facts leading to his death and death of his sister. Manapal died some hours after the statement was made. The statement has been recorded in the nature of a 161 of the CRPC. The thumb mark or signature of the maker is absent. No witness has signed, including the doctor or the nurse. The investigating officer has not recorded the statement in his own hand. He detected the same in other posts. So there was some irregularity for which it was not accepted, my lord. Thereafter, my lord, I'll just place the relevant portion. The case diary discloses about requisition having made for recording the dying declaration statement of the deceased. No such statement has been recorded. By the time the Tahsildar had reached the hospital, my lord, this person had died, for which it was not taken into consideration. But independently, my lord, para 28, the learned trial court recorded, my lord, Exhibit 26, which is the 161 statement. Court came to a conclusion by leaving apart the Exhibit 26, which happens to be the 161 statement, supposedly dying declaration of the deceased, my lord. So there are other corroborative evidence also, my lord. Exhibit 26, which is said to be dying declaration of the deceased, my lord, does not appear credible. But however, the evidence of Devendra, Suresh, Binoy, and Bina is trustworthy. The deposition of PW 20, Manisha is the daughter of the, my lord, appellant. In the maintenance suit by her mother against his father is credible, which shall be given greater importance as against her evidence in court. What has happened, my lord? This Manisha, this daughter, she had turned hostile because she did not disclose about the bad relationship the parents were having. But part of her evidence was taken in consideration, which she had given in a matrimonial suit in a 125 proceeding in Calcutta, my lord. The chemical examination report, Exhibit 21, showing matching of blood group on Rita's wearing apparels with that of the blood on the wearing apparels of accused Boina is an equally strong factor to know complicity of accused Boina. On assessment of these evidences, it's found that Rita and Manna were killed by accused Babu and Boina in consequence of abatement and further common intention. So the fact of 4 independent witnesses who had no previous enmity, the fact of finding of blood on the wearing apparels of the accused, and other correlating circumstances, lead to a conclusive, that's my and Lordship may kindly give me liberty, I'll give
a written note.
And one more last thing, page para 29 onwards, for your Lordship convenient. The knowledge trial court has quoted all the specific role played by each of the appellant, so that will be convenient for your Lordship,
Right.
Para 29 onwards. Each of the appellant's role, specific role attributed to them.
6. All right, orders reserved. The parties are permitted to file the written notes of arguments within 1 week. All right. Terms of the compromise reached between the parties, the IA is taken on board as disposed of. The next date of 22nd April is cancelled.
Yeah, I'm for the petition. My appearance will be
Right. That negotiations are still in progress and they're hopeful of some settlement. List on
After
24th June.
That will do. That. Grateful.
2 to 6.
2 to 6.
Item number 7.
My lord, your lordship was pleased to provide order dated release the petitioner on an interim bail for 2 months, my lord, on the ground of wife illness, my lord.
Right.
And after release, he has taken his wife to a specialist, my lord, and he has detected appendicitis, my lord. And due to some, my lord, high side of the blood sugar, my lord, the surgery doctor, my lord, advised her after 10 days, my lord. And the petitioner is going to will surrender on 14/3/2022. So I pray, my lord, 1 month may allow me. Your lordship may extend.
Lord, your lordship, at that point of time, lordship, because the report was there that she was suffering, having some serious disease, therefore, your lordship was inclined to grant interim bail, my lord. But this time we have not obtained an instruction because this has come to the.
No, but his date of surrender is 14.
Going to be 14/3, my lord.
No, have you placed any medical certificate?
My lord, yeah, I have annexed.
Yes, page 5.
Enclosed page 5.
All right. What is the date fixed for the surgery now?
My lord, after 10 days, he will, my lord, review after 10 days.
No. In that case, sir, let the date be fixed and you renew.
May I pray, my lord, my lord, I will surrender by the end, my lord. By the end of March, my lord. Your lordship may
No. Why? If there's no date fixed, why should you keep
10 days, my lord? After I pray, my lord, only 2 weeks, my lord. 2 weeks.
You surrender, and when a date is fixed, you can again apply for interim bail. Since there is no date fixed yet for the surgery, the court is not inclined to extend the period of interim bail. Nevertheless, you say accordingly the application is dismissed. Nevertheless, it will be open to the petitioner, once a firm date for the surgeries of his wife's is fixed, to again apply for interim bail. All right.
Item number 8.
Item number 8 and 14 are connected. So I have copy of that.
You have to speak in the mic.
Item number 8 and 14 are connected. So item number 8, I am the opposite party. I visit the copy. Let it be taken. Item 14 may be taken along with that. When the item 14.
All right.
Item number 9.
Item 40.
Item number 9.
May I please? I only pray, my lord, for appointment of arbitrator under section 11(6) of the Arbitration Conciliation Act. The agreement.
Who is for the other side?
I am there, Your Lordship. Before Your Lordship takes up the case, I am questioning the arbitration agreement itself. So I have filed a petition IS 7 of 2020 that is not on board.
For him to produce the original.
Original and two read petitions that is disposed of by this honorable court, copy original of those, my lord. Records lying in this.
Give us the numbers.
Numbers, my lord. 21 WPC 2149/18 and 21501 of 2018.
Say list along with those two read petitions. The counsel for the petitioner has brought to the court the original of the agreement. It be placed in a seal cover. Why did you show it to him?
Yes.
Just show it to him.
What I am
It has also been shown.
What I'll praying, my lord. Let me show it to my client as well.
All right.
We
You
are-
say, all right. It
Let
be
it be
placed
with
in a
him.
seal cover by the registrar judicial and kept in a safe custody. It will be open to the petitioner along with this counsel to inspect the said original
Opposite party,
document
my
in the chamber of the registrar judicial.
Opposite party, Your Lordship.
Opposite party. Along with the opposite party to inspect the said document in the chamber of the registrar judicial on a mutually convened date and time prior to the next date. Let's start 8th April.
Item number 10.
There is also in respect of appointment of an arbitrator matter under section 11(6). They have filed the counter there in matter. In the counter, they have accepted the liability to the extent of 70 lakhs 17,245 and have paid it.
What is your objection anyway?
My objection is that, my lords, now the claim which is being made by the petitioner, that is not arbitrable because we don't accept our liability in respect of those items, my lords.
It's all right. That the arbitrator will
No,
determine.
my lords. Arbitration, your lordship must say 13, my lords. When liability is otherwise admitted, then only it can go for arbitration.
No. Most arbitrations, people are denying the liability.
No. Your lordship must see. When dispute...
In 9 out of 10 arbitrations, people will deny a liability.
No. We say that this is not covered under the policy, my lords.
Even that can be decided by the arbitrators.
No, my lords. Your lordship just, may I place that your lordship just
In
here
the
annexed,
latest-
my lords.
In the latest judgment of Mayavati trading matter, the Supreme Court has already held that.
Sir, all these defenses can be taken up in the arbitration.
No, your lordship. If any dispute or difference shall arise as to the quantum to be paid under this policy, liability being otherwise admitted, such difference shall independently of all other questions be referred to the decision of sole arbitrator to be appointed in writing by the parties in difference, or if they cannot agree upon a single arbitrator within 30 days of any party invoking arbitration, the same shall be referred to a panel of 3 arbitrators comprising of 2 arbitrators.
You won't agree to a sole arbitrator will appoint. All your defenses will be left open for consideration. You see, having heard learned counsel of the parties, and reserving the right to advance their respective contentions, both in law as well as on facts before the learned arbitrator, and with their consent, as regards appointment of a sole arbitrator, the court appoints, what is it, 77 lakhs?
Now that has already been.
They have admitted.
We have already paid, my lords.
They
I
have
just
paid it,
need to know what his claim is, please. This is only 11(6). I'm not here deciding the claim.
Claim is 7 crores, my lord. 7 crores. They have paid 70 lakhs.
Would you agree on the name of a retired judge?
My lord.
Your lordship, may
Justice A.K. Ratha?
Anybody, your lordship chooses.
Justice A.K. Ratha, as sole arbitrator to adjudicate the disputes between the parties. The arbitration will take place under the aegis of the arbitration center of the High Court. Right.
Item 11.
May it please this honorable court.
Counter is not filed.
On the earlier occasion, if your lordships would see on the previous order, they had sent a letter to us seeking a reconciliation and a discussion on that. In the meantime, unfortunately, nothing has taken place because no discussion even could be held. So in that context, my lord, I request if your lordships would grant me 2 weeks' time, I'll
Or
file
should
my
we send you
reply.
to mediation?
My lords?
Can we send both of you to mediation? Or if you're able to do it amongst yourselves,
That is, that was the first, that is why I filed a miscase. If your lordships would see that IA 44, the letter that they had sent to us, because that was for mutual discussion only. And on that basis, your
all right, IA 44 of 2021, counsel for the opposite party. You're the opposite party, right?
I'm the opposite party.
Is hopeful that an attempt can be made to settle the dispute through mediation. Counsel for the petitioner is open to the suggestion that the parties could seek to settle the disputes. The application is accordingly disposed of by observing that if no settlement is arrived at before the next date, the matter will proceed on merits.
Yes. And in the meantime, if it doesn't happen, we'll file our reply also.
All right. So in the main matter, you say this on
open for the opposite parties to file the reply so that if
all
the
right,
mediation
29th
fails.
April, if the mediation fails, the replies will be filed to the main petition before the next date. All right. 29th April.
My lords.
Oblige.
Item 12.
May it please this honorable court. I'm appearing for the petitioner in this matter.
Yes.
My lords, the petitioner had entered into an agreement, which is at page 19, my lords. May I kindly have a glance at it. It's an agreement for implementation of a skills development project in Orissa. May I kindly have a glance at the parties clause. The first one, Orissa Rural Development Marketing Society, which is the opposite party, which is stated that under the administrative control of Panchayati Raj and Drinking Water Department, Government of Orissa. Well, the arbitration clause is at page 23.
Yes.
It starts arbitration and applicable laws. The parties hereby agree that any dispute arising in connection with this MOU shall first be addressed mutually by the parties. If the parties are unable to resolve the dispute mutually, the dispute shall be referred to the Secretary, Panchayati Raj, and Drinking Water Department and Government of Orissa, whose decision shall be final and binding on all the parties. So therefore, there is a clear intention between the parties to refer the disputes to a private mode of...
No, is it private mode? I don't know if it's a private mode.
Man, it's a Panchayati Raj, it will be it's not a government institute. Like
no, but it's not a private institution either. This is not a private clause.
He will come under a disqualification under section 12.
So there is no reference to act. There's no reference to the word arbitration.
Arbitration is there at the title of the clause, my lords.
What is your stand?
Yes, my stand is that it is not an arbitration clause.
No, have you filed a reply?
They have issued and we have received reply. I have filed counter. Let's say kindly turn to the.
Correct. You filed a counter.
Kindly, I already filed a counter.
Correct.
Let's say kindly turn to page 11 million. 11 of counter. Yes, this is third parameter. The petitioner issued a notice dated 9/7/2021 under section 21 of the Arbitration and Conciliation Act 1996, indicating that the company will approach the Honorable High Court of Orissa under section 11 of the Arbitration and Conciliation Act for appointment by director. That it was intimated by the opposite party to the petitioner PIA by letter such as that.
No. If it is an arbitration clause, it's only silent about the act. It will still be governed.
My lords.
The act, mentioning the act is not mandatory, sir.
No.
Once you concede that this is an arbitration agreement, then there's no need for the act to be mentioned.
There is no arbitration.
No, the title itself. What is the title of the clause? Come to that. Which page is that?
Title of the clause is clear. That is
23, my lords. 23.
Title of the that
Claims
clause 8.1 arbitration and application laws. But the parties hereby agree that any dispute arising in connection with the MOU shall first be addressed mutually by the parties. So the Panchayat Secretary Millets.
No, what is the meaning of using the word arbitration, the title to the clause? What is the meaning of that?
Because Millets, the SOP.
And the word shall first be addressed.
First be addressed mutually by the parties. Then if the said parties are unable to...
No, so 8.2 is important, sir. In case an aggrieved party seeks judicial remedy.
This dispute shall be referred to the Secretary Panchayat.
No, that's right. Then 8.2.
8.2. In case any aggrieved party seeks judicial remedy, the petition shall be filed.
So the word judicial remedy would include even remedy by way of arbitration.
My humble submission, if Lordship, is first, the dispute must be decided mutually.
All right.
Then, if this dispute subsides, then it will address to the Secretary Panchayat Raj Department.
If you're ready
After
now,
that only,
if you're ready now, we can refer you to mediation. If you're ready now.
My lords,
yes, I am ready.
They've already
let them
terminated the agreement, invoke the bank guarantee, and placed a further demand of 2.5 crores.
The fact is,
no, but that you must have got a stay.
There is no claim.
No,
there is no claim because fact is, the entire fact controls under DDU GKY scheme. There is a scheme formulated by the central government.
So no claim is from your point of view.
There is no claim there. There is no claim.
They have sent you a notice. What are you saying? There's no claim. They have just sent you a notice asking for arbitration. How do you say there's no claim?
Yes, because they don't have any claim. Because we are having a claim because we have.
What is the purpose of sending notice to you, sir? If they don't have a claim, why did they send notice to you just like that?
Yes, we have stated that it is not
what you have stated. If they do not have a claim, why are they sending you an arbitration notice?
Because we have blacklisted them. And
there is a dispute between the two of you. You have to acknowledge that.
Yes,
that dispute, he wants to refer it to arbitration.
Yes, the dispute is yes, they have taken money from us.
That is your dispute with them, sir. He has a dispute with you. So both have disputes with each other.
Yes, we have also disputed.
Correct. So why don't you get it settled through arbitration is the only question. You also have a dispute. He has also a dispute. What is the point in denying arbitration? Does it serve anybody's purpose?
The SOP, the entire matter is controlled under SOP. That is the guideline.
What is the value of your claim?
Guideline. It will be about 3 crores.
And what is the value of your counter claim?
There is no claim of 3 crores.
Sir, what is the value of your counter claim? You just now said they owe you some money.
Just a minute, please.
At page 36, they have sent a demand letter. It will be about 2.89 crores, excluding the bank guarantee.
Virtually, he has 3 crore claim. You have a 3 crore claim.
Because the fact is, they have no claim yet. The fact is,
sir, today in 11.6, am I supposed to decide this? In 11.6, I have to say you have no claim, dismissed. Is that the scope of 11.6?
The thing is that because I have advanced them. I don't know.
Okay. Anyway, there's no point in asking you questions that you don't want to answer. Yes. All right.
The fact is, just now, only 2 minutes I will send them that question. The fact is, it is controlled under one SOP. It's a guideline of the central government. As per the guideline, if anybody wants to recover, he will adopt the revenue recovery proceedings. So that I have stated just you have to kindly turn to page 15 of my counter minutes. I have stated furthermore, the provision of the arbitration council action 96 is not applicable as per the provisions of the SOP of DDU GKY. This provision is applicable to him also. This SOP guideline says that the recovery of only can be done through Revenue Recovery Act 1996 or Public Demand Recovery Act of the state. So my humble submission is that this Arbitration Act is not applicable. If anything he has to recover, or if he has to say, he has to adopt the revenue recovery proceeding. This is my counter. I've stated in page 15 minutes.
You say the petitioner has approached this court in the present petition under section 11 bracket 6 of the Arbitration Conciliation Act 1996 bracket Act, seeking the appointment of an arbitrator to adjudicate the disputes between the petitioner and the opposite party arising out of a memorandum of understanding dated 7th February 2018 bracket MOU. Counsel for the petitioner has drawn the attention of the court to two facts. One is one is clause 8 of the MOU, which according to the petitioner is an arbitration clause. The second is the notice dated what is the date of your notice, sir?
9/7/2021.
The arbitration notice, Malox?
Arbitration notice.
Well, it's
9/7/2021.
Malox. It's page 50.
50.
Malox.
The other is a notice dated 9 July 2021, sent by the petitioner to the opposite party, seeking the appointment of an arbitrator, raising a claim of regarding illegal encashment of a bank guarantee,
As well as termination.
in the sum of rupees 72,700,017 and illegal and unlawful termination of the MOU. The petitioner is also questioning the demand raised by the opposite party on the petitioner for refund of rupees 258,09,193.05 paragraphs. Counsel for the opposite party, on the other hand, refers to the counter affidavit, where it is sought to be contended that the act does not apply at all. It is further denied that the petitioner has any valid claim against the opposite party. To stop, according to counsel for the opposite party, the only remedy available to the petitioner is to go for recovery under the Revenue Recovery Act and not otherwise. Paragraph. The relevant clause of the MOU, which is relied upon by the petitioner, is clause 8, which reads as undertake from page 20. The above clause envisages the parties to first seek to address the dispute mutually, and if they were not, and on failure to do so, to refer the dispute to the Secretary Panchayat Raj and Drinking Water Department of the Government of Orissa. Full stop. Those stages have obviously been crossed since the parties have been unable to resolve their disputes inter se. Clause 8.2 clearly states that if an aggrieved party, open quotation, seeks judicial remedy, unquote, then the petition will be filed in the jurisdiction of this court. But so the expression single quotes judicial remedy, unquote, would include the remedy of filing a section 711, 11 bracket 6 of the Act asking to go out. Why don't for seeking the appointment of an arbitrator. Full stop. In the present case, the fact that the clause is titled single quotes arbitration applicable laws clearly reflects the intention of the parties that their dispute should be resolved through arbitration. Consequently, the court rejects the plea of the opposite party that the act does not apply at all. Paragraph. As regards the tenability of the petitioner's claims, this again is a matter to be decided in arbitration and not by this court as in the present proceedings. Incidentally, counsel for the opposite party submitted that the opposite party has claims against the petitioner as well. Paragraph. Consequently, the court, while leaving the contentions of both parties on merits open to be urged before the learned arbitrator in accordance with law, appoints Justice Pramod Patnaik, a former judge of this court, as the sole arbitrator to adjudicate the dispute between the parties, including the claims and counterclaims. The arbitration will take place under the aegis of the Delhi High Court arbitration. The petition is disposed of.
Item number 13.
Item number 13, notice was issued on the 21st of January. And the noting shows that counter affidavit has been filed by the opposite parties number 1 and 2, but I have not been served with any copy.
All right. Copy of the counter affidavit be served on counsel to the petitioner who is permitted to file a rejoinder for the next date. 22nd April.
Item number 14.
In item number 14, I appear for the petitioner from Calcutta, myself Kishore Datta.
Yes.
Lord, this is a section 29A application.
Right.
Your Lordship knows, my Lord, by an order of 10th of January 2022, the Honorable Supreme Court was pleased to, my Lord, exclude the period between 15th of March 2020 to 28th of February 2022 for the purpose of, my Lord, calculating 29A period as well as section 23 subsection 4.
In this case, Your Lordship,
this is number 1.
Item for
number 2 is, please permit me to complete.
Okay.
Number 2 is, item number 8, is an application filed by the respondent, for under section 14 and 15 of the Arbitration Act.
Right.
There are certain allegations in the section 14 application, which I would like to respond. And so far as my 29A is concerned, by reason of the order of the Honorable Supreme Court of 10th of January, I believe now I am safe within the period of limitation.
So this item 14, I'll say you're not pressing it for the moment.
Please keep it pending, because the section 14, I would be seeking some time to file my opposition. And please fix
in this case, Your Lordship, in this matter, so far as my learned friend is item arbitration item 2 of 2021, I have filed my counter and IA yesterday, and copy has been sought.
All right, so we are issuing notice in your item 8. All right.
Lordship. I am the counsellor, Lordship.
Item 8, do you want notice to be issued or you don't want notice to be issued?
Yes, please.
All right. Item 8, you say notice. Mr. Datta accepts notice on behalf of the opposite parties and prays for and is granted 4 weeks time to file his rejoinder for the next date.
Yes.
29th April. In item 14, you say list along with
item 8.
Item 8 on the same day, 29th April.
Well, I have filed an application for IA. In the meantime, Your Lordship, the mandate of the tribunal has been ended since 12th.
Sir, it is not. So you do not, let us take a call on all this on 29th. Please study his petition and then make your submissions. All right.
In the meantime, I pray, my Your Lordship, I have filed an IA. I pray that in the meantime, during this period, the learned tribunal may not proceed in the matter.
I'm not passing any such order now. Yes.
I may be pardoned, my lord. Pardon to make a mention, my lord. I have filed an application for extension of the arbitration proceeding to conclude, my lord. So that may be in the next.
Whom are you appearing? How come there are so many counsel? Whom are you appearing for? Sir, we are in the midst of a case now. How come you suddenly standing up and saying something?
My lord, in this matter, arbitration tribunal has been become functus officer since 12th of February. That is why my case is he may not proceed in the matter. Matter posted to 19th of this month. That is why I pray I have filed an IA.
Sir, his contention is because of the order of the Supreme Court, the period for conclusion has got automatically extended. Kindly study that before you make submissions, sir.
Lordship, I know that, but during this period also, the learned tribunal also continued in the proceeding through virtual.
Anyway, sir, anyway, it's up to you. We are not here. I'm not here to give you free legal advice. All right, 29th April.
Item 13. Item 13, my lord. Item 13, my lord, fixed to 22nd of April. Item, so may I pray, can it be earlier or not on 22nd?
All right, 29th.
Okay.
Pardon to make a mention, my lord. I have filed an application for extension of time for conclude the arbitration proceeding.
Which matter is this, sir?
My lord.
It's a fresh matter.
To conclude the arbitration proceeding.
No, is it a fresh application that
yes,
you have filed?
I have filed a fresh application.
Is it numbered?
Yes, my lord. 6 of 2022. IN number 6 of 2022. And I'm giving the memo. My lord.
All right, 25th March. All right. Over. Right.
Sorry.
No,
Good afternoon, sir.
Supplementary stress admission item number 1.
My lord, the item 1 may kindly be taken up 1 week after, my lord.
We're not adjourning like this. Please, we can't keep sitting like this. Carry on.
Learned Counsel, please come to that order which you are seeking review. Paragraph number 6.
My prayer is to expunge the remarks passed against the opposite party number 5, my lord.
No, your prayer is that to seek review of that particular order. That is 5 to 2019.
Miller.
Passed in WPC number 16348 of 2018.
Miller.
And in paragraph number 6, it is mentioned that an interim arrangement was made. That is.
Justice Sahu.
Yeah.
He's now saying that he wants the observations in para 5 to be expunged. That's the whole purpose of the review.
Paragraph 5. So the Learned Counsel also confirmed that the fact regarding the continuance of the vigilance inquiry against for the.
But this is a statement that the counsel must have made.
No case is pending against me, my lord. No, not a single piece of paper is produced against me that vigilance case is pending against me.
That is the submission of the Learned Counsel. We have not stated anything that was the submission made by the Learned Counsel.
No, the only word is confirmed. Maybe we can clarify that it's only a submission recorded
and that was the opposite party number 4 is the Director of Vigilance, Orissa. That is the. And they made a submission that vigilance inquiry is going on.
Yeah, so we can say the word confirm should not mean that the court has observed anything. We are only recording the submission of. All right.
That order may be complied to form the Waqf board, my lord.
Mr. That is what
that is a separate thing. That's not part of a review petition, sir. You say counsel for the review petitioner states that the observation para 5 of the order dated 5th February 2019, which records the submission of counsel for opposite party number 4, that a vigilance inquiry is continuing against opposite party number 5 for the allegations mentioned in the previous paragraphs should be clarified, since according to him, no such inquiry is pending against opposite party number 5. Paragraph, it is clarified that this court has only recorded the submission of opposite party number 4 and has not expressed any opinion on the correctness of such submission. Full stop. The review petition is disposed of.
Obliged. For orders item number 2.
Yeah.
All right. The office note has been observed. The order with the corrected appearance be issued as prayed for. All right.
Item number 3.
My lord, I am appearing Union of India in the item number 2, my lord.
All right.
My lord, item number 3, my lord.
Yes.
In this matter, the petitioner appellant is convicted under section 302 of the IPC, my lord.
Right.
Only on the basis of his admission and recovery of the used weapon. But
Right.
the weapon is not medically examined and there is no forensic report. There is no eyewitness to the incident, my lord. And since last 10 years, he is in custody, my lord.
Who's for the state?
I for the state.
Mr. Katke, any idea of his antecedents? Where is he? Who? He's a resident of which place?
Cuttack, Cuttack.
Any antecedents?
Get the antecedent, no antecedent.
Do you, Mr. Katke, do you have a report?
No, I don't have the report. I'll get it. Am I not audible, boss?
According to you, there are criminal antecedents.
No, I don't have the antecedents. I have not got any report. I'll get it by the next date. Your Lordship should permit me to get the report within 1 week or 2 weeks.
Justice Sahu, should we then await that?
But of course, he is right that the injured is an eyewitness and he didn't support the prosecution case.
Yes. I supported, but let it come after municipal election laws.
Municipal election, okay.
All right, Miss Case number 1689 of 2017. Mr. Katke seeks some time to ascertain the criminal antecedents of the applicant, appellant. At his request, list on 8th April, sir. 8th April.
It will apply to.
All right. Thank you.
Sir.
Good afternoon, Mr.
Sir.
I may be pardoned to appear through VCO, Lordships.
Yes.
Supplementary list item number 1.
Yes.
Lordships, in this matter, only my limited prayer is because the original issue is before Honorable Apex Court.
Yes.
Authorities declined to adjudicate the matter. So my humble prayer before Lordships that let them implement the order subject to result of this, that civil appeal, Lordships. Mr. Chimanka is appearing also.
Yes, my lord, I am appearing.
Are you agreeable to the prayer?
Yes, my lord.
All right. IA number so and so. As per counsel for the opposite party states that he has no objection to the prayer being granted. Accordingly, it is directed that the order dated 16th September 2021 passed by this court may be implemented subject to the outcome of CA number 10763 of 2017 pending before the Supreme Court of India. The application is disposed of.
For admission, item number 2.
Item number 2, I have submitted the instruction as directed by the Honorable Court. Lordship, it is there in the record.
There is no appeal or revision filed, my lord, against the order
The
of the
District Office Puri has intimated us that there is no appeal pending against the order of the consolidation officer.
All right. Then what should happen now?
Review to be allowed, my lord, because it's paragraph 9, my lord, what had happened. The writ application dismissed on the ground that lawful owner and in possession, my lord, that was not there. And the consultation officer has already adjudicated the matter in my favor, and they have not filed an appeal.
Oh, then this order has to be reviewed.
Yes.
Then the original writ petitions have to be allowed?
Yes.
All right. Is that right,
No,
Mr.?
no, sir. Original writ petition has to be heard again. Because we have not gone to, because once, sir, the order has been passed based on the
statement
made under Annexure 1 and Annexure 9.
Correct.
That a consolidation revision has been preferred by the government against the order of the objection case.
Right.
So now the other points are there which we have not dealt with.
So we'll restore it to the roster bench.
Roster bench.
Yes.
All right.
The writ petition has to be reheard.
All right. You say, Mr. D.K. Manti, learned additional government advocate, has placed before the court a written intimation received by him dated 15th February 2022 from the Additional District Magistrate Revenue Puri, confirming that there is no appeal pending against the order of the Consolidation Officer Puri in objection cases 2567 and 2568 of 1996 in any higher forum. Paragraph. In view of the above statement, the order passed by this court
in WPC 4737 of 2003.
On 12/8/2021 in WP Civil, both these numbers 4737 of 2003 and same date the other one, right?
Yes, ma'am.
Yes.
And 10969 of 2005 is hereby recalled, and both writ petitions are restored to the file they will now be listed before the roster bench.
Because it is an year-old matter, this is to be listed before this honorable court. 2003 matter. So
Okay.
roster bench is this bench.
This court. So for the roster bench on 11th April.
Whichever date, Manoj.
11th April.
11th?
April.
Yes.
All right. All right. Okay. Right. Right. Right.
Pranam, sir.
Pranam.
For judgment item number 1, WPC 6997 of 2004.
Writ petition is disposed of by a direction to the railways to pay the revised pension by granting notional promotion to the petition.
I agree.
Item number 2, WPC 8080 of 2009.
The impugned order of the Central Administrative Tribunal is set aside. The writ petition is allowed with no orders as to follow.
I agree.
For admission item number 2.
3.
Item number 3, review petition 10 of 2020.
For the opposite party.
Passed in the case for the review.
You'll have to speak louder, Mr. Mishra. You're not audible.
My lord, there is a noise from somewhere, my lord. Am I audible now, my lord?
Slightly better.
Speak little closer to the microphone, Mr. Mishra.
My lord.
Now it's clear.
My lord, there was a noise from somewhere, my lord.
Right.
I am extremely sorry, my lord.
Right.
My lord, the case was disposed of. Your lordship will kindly peruse the order dated 15/12/2021 passed in WPC number 20159 of 2021. On the basis of the order that has been passed in the WPC connected case, WPC 22240 of 2021.
Correct.
That was disposed of on the premises that on 6th December 2021, the GAIL filed an affidavit saying that they are taking measures for safety. But the primary grievance was this being all homestead land, and one of the person having already raised the house and others will come up with house, it will be unsafe because the minimum space that is required for pipeline is not available at the place. What they had done in the affidavit, my lord, your lordship, they had said that we are keeping 8 meters. There are 8 meter space, that is, my lord, the route where the pipeline will go for the purpose of laying the pipe. Now, I filed this case, my lord, I have annexed documents with regard to safety measures, that is from page 153 onwards to show that unless there is 15 meters on either side of the pipeline, my lord, it will not be safe to have homestead building there. And that is the basis on the basis of which your lordship was pleased to call upon GAIL authorities to file an affidavit on the submission made in the review application. Now, the GAIL authorities also have filed an affidavit, your lordship. Your lordship will kindly turn to page 13 of the affidavit that has been filed to this review petition, your lordship. Therein in paragraph 30, they say initially it was 20 meters. And because 20 meters is not available, they have reduced it. But what they have said in page 14, your lordship may kindly see top. The 8 meter statement they had given, they have changed it saying that it is 6 to 8 meters. Because my contention in the review petition is also that in fact, on this spot, it is 6 meters only, not even 8 meters what they had said in their affidavit earlier, on the basis of which it was disposed of. Now, fact remains, my lord, so far as the space is concerned, to some extent they have said that it is 6 meters. Because your lordship will see, the ROU width was reduced to 6 to 8 meters. Now they have said. So what I humbly beg to submit, my lord, this will be totally unsafe. If the gas pipeline my lord, is used, it will be totally unsafe. Because your lordship will see, so far as this, my lord, right of user is concerned, my lord, your lordship will see I have annexed. Your lordship may kindly see.
So the originally proposed ROU is 20 meters.
Yes, because 50 meters is the minimum on either side. That will come down to 30 meters. So they had 20 meters. Because there is no space, they reduced it to, they said in the affidavit that was filed on the basis of which the case was disposed of, your lordship, 8 meters. Now they have changed it and they are saying 6 to 8 meters, because I contended in the review petition that it is in fact at the location 6 meters, even not 8 meters. Now, my lord, the other aspect is, my lord, your lordship will consider, now so far as the piling and everything is concerned, it will damage every building, my lord. And it will be unsafe because the bent where, my lord, the gas has to flow, but unless there is adequate space on the either side, it will be unsafe to have a residential house there also.
Have you issued notice in this?
Your lordship was pleased to issue notice. Your lordship called upon the GAIL Council to file an affidavit, and they have filed an affidavit.
Let's see that.
And that affidavit I was pointing out page 14, your lordship will see. In fact, from page 13.
Yes.
Paragraph 30, they have said page 13, your lordship, towards lower middle portion, 20 meters. Initially, it was in the notification 20 meters, my lord.
Right.
Now, your lordship may kindly turn to the next page, page 14, top para, second line. They have now said it is 6 to 8 meters. In the earlier affidavit they had filed, on the basis of which the case was disposed of, they have said it is 8 meters. And in the review petition, I said it is in fact 6 meters, even not 8 meters. Now it will be totally on, and I had also given a map, your lordship, even which I have also annexed to the review petition, to show the alternative line will not cause any inconvenience. Even there was proposal for drawing up electricity line, high voltage electricity line in that zone, and it was diverted also. So therefore, my lord, if it is diverted, my lord, no prejudice will be caused. That is what I beg to point out, my lord.
No, prejudice meaning cost. What about the cost? Because you'll have to take out the entire pipeline. No, they've already laid this pipeline, correct?
But that is, my lord, after the order was passed, I filed the review petition. At that point of time, by employing police, they have done it. It was not done till the writ petition was pending, your lordship. Post facto, the disposal of the writ petition and this review being filed and considered, this has been done. It's a fact, my lord. I have to, because I have taken instruction also, they have laid.
This ROU being 20 meters, is it put into the statute, or how do you get it?
My lord, that is the safety measure which I have also, my lord, different, your lordship will see. I have annexed these documents which commences from, it is not exactly written in the statute. I was just finding out. But fact remains, the guidelines which I have annexed from page 153 onwards, that has not been disputed by the counter affidavit filed by the GAIL authorities.
So those guidelines say 20 meters.
Not 20 meters, even 30 meters, your lordship. Either side of the pipeline, 15 meters.
Oh.
And they have purposefully kept it 20 meters because that will be the minimum safety measure. And they reduced it to 8 meters. Then now in the counter affidavit, in the review, after the review petition was, notice was issued, they say we have kept it 6 to 8 meters. That means my contention that it is in fact at the locality 6 meters is virtually admitted in the counter affidavit by saying 6 to 8 meters.
Yes, what do you say?
Yes. My lord, I'll just take my lords back to the how the order dated 15 December 2021 was passed. My lord, the grievance of the petitioners in the writ petition was based on section 7(1) small a of the PMP Act, and the contention was that no pipeline can pass through homestead land. The principal grievance in the writ petition was that they will not be able to construct houses on the plots which they had purchased. There were no constructions on the date of the notification. And as on date also, there is a single construction which has come up after the date of notification, because the writ petition does not disclose the date, specific dates of purchases of the plots, the conversion, the mutations. Now, my lord, in that background, my lord, an affidavit, this court wanted an affidavit to be filed, right? It's order dated 22nd July. And that affidavit, my lord, was required specific to the issue of laying of pipelines under the homestead land. And pursuant to that, my lords, this affidavit came to be filed, that is on 23rd August 2021. And at para 16 of that affidavit, which is also reproduced in the review petition, my lords, that is at page 14 of the review petition, my lords.
Yes.
Roman 11, XI. So, my lord, a proposal was advanced so that the grievance of the petitioner is redressed and there is no major diversion of the route. And therefore, my lord, what was proposed, now it is, if I may place that para XI at page 14 of the review petition, my lord.
XI, is it?
Yes, 11. Now it is proposed at the middle of that paragraph, my lord. Now it is proposed to lay the pipelines under the internal road within Om Vihar, in respect of which right of user West Sin GAIL India Limited, and further to restrict the width of the pipeline to the width of such internal road. My lord, the 20 meters that is referred to my learned friend, that is for the purpose of facilitating construction for the movement of vehicles during the time of construction and laying of pipelines. My lord, these pipes are very heavy pipes, around 12 meters in length, so some space is required. In view of the...
No, this was your stand in the main writ petition.
Yes, my lord. This was the stand that we will reduce and we will restrict our pipeline to the internal road. My lord, the internal road, the pipeline has a diameter of 12 inches. Pipeline has a diameter of 12 inches. It was to be laid at the center of the internal road so that it does not interfere with the individual plots and deprive the petitioner from going ahead with construction. My lord, that is how this affidavit was filed and this proposal was given. My lord, thereafter, through the rejoinder affidavit, certain apprehensions were voiced regarding the safety. And a reference was made, my lords, to para 4.2.5 of the PNGRB regulations 2016, which is also annexed to the writ petition, my lord. My lord, to turn to page 119. This starts from page 96, these regulations. My lord, these regulations start at page 96, annexure 9 of the review petition. And my lord, to turn to page 119, my lord, at the bottom, 4.2.5, if my lords have it.
Yes.
No pipeline. This is the provision on the basis of which that those apprehensions were raised. No pipeline should be located within 15 meters of any dwelling unit or any industrial building or place of public assembly in which persons work, congregate, or assemble, unless it is provided with at least 300 millimeters of cover over and above minimum cover specified in table 3, or any other mitigation measures provided like higher pipe wall thickness or protection with RCC slab. No dwelling unit or permanent structure in any form shall be permitted within the ROU or ROW. So, my lord, what was endeavored to be advanced was that there is an absolute bar on any construction within 15 meters of the ROU. But, my lord, the subsequent part of this regulation 4.2.5 says that this is subject to adoption of suitable mitigation measures. And those mitigation measures have been specified.
No, where does it say suitable mitigation measures?
My lord may see, unless it is provided, the last line of at page 119, unless it is provided with at least 300 millimeter of cover over and above minimum cover specified in table 3. My lord, table 3 is at the top of page 119.
Yes.
My lord would see this is the locations, different kinds of location, rocky terrain, drainage, canals and all. And then the minimum cover is provided, ranging from 1.2 meters, 1 meters to 1.7 meters. So in this case, my lord, the pipelines have been buried at a depth of more than 2 meters. And then the thickness of the pipeline, because the next page, my lord, should find or any other mitigation, like in para 4.2.5 of the regulations at page 120, the top, apart from the depth or any other mitigation measure provided, like higher pipe wall thickness. So these higher mitigation measures were also assured through the affidavit dated 9th December in this matter, my lord. So, and an assurance that the provisions.
Have you followed 4.2.5 in this case?
Have you
4.2.5? Have you followed?
Yes, my lord. Yes, my lord. The affidavit.
Whatever is suggested there, that RCC slab cast, all those things you have provided.
Yes, my lord. If one just
that extra pipeline, extra thick pipeline and RCC slab.
Yes, my lord. Extra thickness pipeline, 8.7 mm thickness pipes have been laid, and
yes.
The depth is also 2 meters. As
and RCC slab you have provided.
RCC I have to take instruction because the
yes, whatever safety measure is provided,
yes,
you must follow that.
Yes, my lord. My lord, there can be no compromise with safety measures.
Yes, Mr. Mishra.
Actually done it is
In that 4.2.5, it says even below 15 meters they can provide, provided they follow the procedure laid down therein.
I'll just clarify.
If they take all the safety measures.
My friend just now said he will have to take instruction whether the safety measures have been taken or not.
My lord.
So you filed an affidavit to that effect.
My lord.
And you have followed all this procedure. You have taken adequate safety measures as stated here in this 4.2.5.
My lord,
that will solve the problem.
My lord Justice Mahapatra, may I just point out one more thing? The earlier affidavit which they filed on the basis of which the case was disposed of, if your lordship will kindly turn to page 24 of the review petition which I have quoted. Only I have quoted in extenso whatever they had stated in their affidavit. They had said this right of user is having 8 meters. Your lordship will kindly see. That has been again reduced to 6 meters.
So let him take instruction. He wants to take instruction. Whether this RCC slab has been provided or not.
As your lordship pleases.
Let him take instruction and file an affidavit to that effect.
As your lordship.
And if possible, you can also, Mr. Mishra, you can also take opinions of some experts. There are safety experts.
Justice Mahapatra, I think what would be best is this. We will have a video clip taken because how many dwelling units are there, Mr. Mishra, now? Because according to GAIL, there is only one dwelling unit. All the others are vacant
one
blocks.
dwelling unit. All residential unit has to, because it's a residential zone. Residential unit will come up as per the safety measure prohibition.
No. In which case, see, we need to think of two aspects here. Right now, they're all except one plot where construction has come up. The others are vacant plots.
Others are bounded vacant plots.
So let us have a video clip taken so that we know where the pipeline is running vis-a-vis these plots.
And one more thing I beg to point out, which also I will display. My friend may get a video. I will get a video like in the other PIL I had displayed, my lord. The other aspect is whether they will be allowed to do construction work because the prohibition is as per the guidelines.
Correct. That's why I'm saying 4.2.5 now puts a prohibition on dwelling units coming up.
Exactly. So that is another difficulty, my lord. So that aspect is to be gone into. And that is also the expert guideline.
The other way around, having put the pipeline, you now tell him you cannot raise a dwelling unit.
Because that will be vibration.
May I please clarify? My lord, the restriction is only limited to the ROU, that is the right of user, the easement that is acquired for laying the pipelines, which in this case is restricted to the internal road. The plots are adjacent to the internal road, to that particular road, and there is no bar on construction. That is the very purpose why this realignment was done. My lord, and the mitigation measures that were proposed in accordance with the PNGRB guidelines were laid out in that affidavit of 9th December.
Anyway, you file an affidavit. You say before the next date, GAIL will file an affidavit indicating whether all safety measures envisaged in clause 4.2.5 of the guidelines, is it? What is this called?
My lord, this is the Petroleum and Natural Gas Regulatory Board technical standards and specifications, including safety standards for petroleum and petroleum product pipeline, within brackets, regulations 2016.
Of the 2016 regulations, bracket Annex 9 to the review petition, notified on 12 February 2016, have been strictly complied with in letter and spirit as far as the pipeline in question is concerned. Paragraph. Additionally, both counsel for the review petitioner as well as GAIL will place and record video clips of the exact location of the pipeline vis-a-vis the dwelling units / plots in question to enable the court to appreciate the precise location of the pipeline.
Much obliged.
Right. List on. We'll have it on 8th April.
Your Lordship, please.
All right, 8th April.
Since the matter has been completed, may I share with my personal experience? In my agricultural land, GAIL has also laid down the pipeline and they have demarcated, no, you can't construct any type of construction over this portion. They have marked.
My lord, actually pipeline markers are laid along the ROU to identify so that this is kept
all
safe.
types of civil constructions are prohibited.
Yes, civil constructions are prohibited. Yes.
All right.
Obliged, my lords.
All right.
Item number 4.
My lord,
I am for the opposition.
yes, let me submit. With a very few minutes I will take. This is that petition in which I sought for a review of the judgment of final order of the court, solely on the ground that there was an interim order for measurement of the land and that order has not been implemented, not complied, and the final order was passed directing us to pay the compensation. But what the very lengthy objection has been filed, your lordship may kindly come to page 6 of the objection filed by the opposite party, page 6. Last line, the opposite party humbly submits that the Tahsildar had noticed him and in his presence, 2 numbers of plots were duly measured by the Tahsildar Bhubaneswar and found that acre 023 decimal of land from each of the plots have been used in the road and pipelines among other things, and the report is on record of the case. If this is there, then I have no cause of action to proceed with if such a report is there, if my learned friend will give that report, I will suggest my client to pay the compensation. This report which he has relied upon in para 17 at page 6.
Well, Tahsildar already filed a report before this one.
It may be a communication gap. Let me find out, or my learned friend may give it that report. I will suggest, and on that, your lordship can dispose of the review petition.
All right. In the counter affidavit filed by the opposite party, in para 17, a reference is made to a report of the Tahsildar Bhubaneswar measuring the
pursuant to the order of this honorable court.
Measuring the plots in question pursuant to the order of this court.
Dated 6/11/2019.
The report is stated to be dated 6th November.
No, the order is 6/11.
No. Okay, full stop. This is supposed to have happened pursuant to the order dated 6th November 2019 of this court. Full stop. A copy of the said report.
No, sir, we have not received copy.
Then how you say so?
Sir, at the time of measurement, they say 23 decimal.
No, then you can take instructions whether any such report is there.
Then
Mr. D.K. Manti states that
he has confirmed that there is a report 23 decimal. Now he is saying that we have heard it from the Tahsildar.
Yes.
All right.
I will take instructions.
Mr. Manti seeks time for instructions on whether such a report was in fact
available
prepared.
in the office of the Tahsildar and whether any measurement was
That's
done.
Right. Whether in fact any such report was prepared. List on the same date, 8th April. All right.
Supplementary list item number 20. Item 20, WPC 1429 of 2022.
So do we have the report? We would ask for the report of the collector.
Report and the pen drive is also with me.
All right, let's see that. There's a report.
Report of the collector. Report of collector. Very cryptic report. Collector report.
That is the affidavit.
Kind of court.
It is filed already in mail. I'm sorry, in e-filing.
Okay.
To play the video, we can. Fast forward. Fast forward. So all the lawyers are there. The Sarpanch, is it? The last person?
Yes.
1 minute.
Yes, he is the Sarpanch.
Just let's hear them.
That is in Orissa for us.
It's all right. Justice Patnaik could understand.
उच्च न्यायालयକୁ ମୁଁ ସାର୍ମାନଙ୍କୁ ନିବେଦନ କରୁଛି ସାର୍ ଏବେ ଯେଉଁ ବର୍ତ୍ତମାନ ଆପଣ ଗୋବିନ୍ଦପୁର ହଉ ମାହାଳା ପାଟଣା ଢେଙ୍କିଆ ତ୍ରିଲୋଚନପୁର ଲୋକମାନେ ମତାମତ ଦେଲେ ସେମାନଙ୍କର ମତାମତ ଆପଣ ସୁଚିନ୍ତା ବିଚାର କରିବେ ଲୋକମାନେ ସ୍ୱମତ ବର୍ତ୍ତମାନ ପ୍ରକଳ୍ପ ଚାହୁଁଛନ୍ତି ଏଠି ବର୍ତ୍ତମାନ ଲୋକଙ୍କର ଜୀବିକା ଚାଲିଯାଇଛି ପାନବର୍ଷ ସ୍ୱମତ ବର୍ତ୍ତମାନ ସରକାର ତାଙ୍କ ଜାଗା ନେଇ ସାରିଛନ୍ତି ଯଦି ପାନବର୍ଷ ନ ବଢ଼ାଇଥାନ୍ତା ତାହେଲେ ଆମେ ଲୋକଙ୍କ ପାଇଁ କିଛି କହିଥାନ୍ତୁ କିନ୍ତୁ ବର୍ତ୍ତମାନ ଲୋକ ପାଇଁ ଆଉ କହିବାର ଆମର କିଛି ନାହିଁ ଏତିକି କହିବି ଯଦି ସରକାର ସେ ଜାଗା ନେଇ ସାରିଛନ୍ତି ବା ଡ୍ୟାଲ ବୁଲେଇ ସାରିଲେଣି ତେଣୁ ସେ ଜାଗାରେ ପ୍ରକଳ୍ପ ହେବା ଆବଶ୍ୟକ ଅଛି ଏ ପଞ୍ଚାୟତର ବେକାରୀ ସମସ୍ୟା ଦୂର ହେବାର ଅଛି ବେକାରୀ ନିଯୁକ୍ତି ହେବାର ଅଛି ଲୋକମାନଙ୍କୁ ବର୍ତ୍ତମାନ ବେରୋଜଗାରୀ ହେଇଯାଇଛନ୍ତି ପାନବର୍ଷ ଭାଙ୍ଗିଲା ପରେ ତାକୁ ଶୀଘ୍ର ନିଯୁକ୍ତି କରାଯାଉ ଏବଂ ଶୀଘ୍ର କମ୍ପାନୀ ଏଠାରେ କରାଯାଉ ମୁଁ ଆଜି ଉଚ୍ଚ ସ୍ୱରରେ କହୁଛି କାହିଁକି ନା ଆପଣମାନେ ମୁଁ ସରପଞ୍ଚ ହିସାବରେ ବହୁତ ସପକ୍ଷ ହୁଅ ଯିଏ ସବୁ ସପକ୍ଷ ହୁଅ ବିପକ୍ଷ ହୁଅ କେବେ ସରପଞ୍ଚକୁ ଲୋଡ଼ା ହେଇନାହିଁ ଏ ଜନସାଧାରଣଙ୍କୁ ମୁଁ କହୁଛି ମୁଁ ସବୁବେଳେ ଦେଖେ ଲୋକମାନଙ୍କ ମତାମତ କଣ ଲୋକମାନଙ୍କ ମତାମତରେ ଆମେ ଦେଖିବୁ ପାନବର୍ଷ ଭାଙ୍ଗିଦେଲେ ନିଜ ସ୍ୱଇଚ୍ଛାରେ ଭାଙ୍ଗିଛନ୍ତି से कहार की कही ना किंतु जदि पानहार भांगी जाइछ एबे कंपनी की स्वागत करो कंपनी हो आपण मानकर पुणे एठी नियुक्ति पांतु बेकारी समस्या दूर हो देशर मानदंड बढ़ू राज्यर मानदंड बढ़ू तो मोर एति विशेष मु कहिबेनी कि साल को समय देबेनी किंतु एति कहि मोर मंतव्य रखिली जय जय किसान
To make your submissions.
May I say? Dear my lord, in this collector's report, Lordship may find in the last page, out of 69 persons who spoke on that day, 16 persons have been the victims of police atrocities. That is the report, and who are the persons, they have also named it.
All right.
In a format, my lord.
Correct.
And till today, the 6 persons, they are inside custody. And 30 persons, they are remaining outside the village. Till as on today's morning instruction, they are not able to return to their village because of arrest, all this threat of arrest.
No, but I already told you to give the names of those persons.
I have collected the names. I will furnish them. I assure today morning I got, because there are some problem in communication with those people. So the names could not, but today I have collected.
So only today you are going to do it?
No, already. I have got already.
No. I'm saying you have still not handed it over to Mr. Mohanty.
Yes, by Monday. By Monday I will hand it over. 30 persons. And the interesting feature of that day meeting is that in every short intervals we have to request to the SP that kindly intervene. Many people want to come and express their voices. They have been prevented outside this meeting place. And in one situation, we have to leave the place, go outside, see that some ladies, they were not allowed by the police and other people, and we intervened and allowed some people. And this has been a repeated feature of the meeting. And as we gather, my lord, that day, particular group of people carried in vehicles, given foods, all these things, they occupied the chair much before the meeting started, my lord. They are a particular group of people. And the other people, a 15-year-old girl, she came. She was not allowed to enter. She is a victim of police atrocities. She has been beaten, but she was not allowed to enter. We intervened. She came, but she was not allowed to speak. My lord, these are the features, my lord. And presently, my lord, the meeting, that public hearing, as it was collector declared, we also declared that this is not a meeting
to say whether the establishment of the company would be there or not, my lord. This is only restricted to the point that whether you have been a victim of the police atrocity or not, or any other atrocity by the company people or the administration in any way, my lord. So the Pollution Control Board, prior to this meeting, my lord, they have held a meeting regarding getting the consensus of the people regarding whether to establish the JSW or not, my lord. So even though accepting that many people, they want the establishment of the company doesn't have a, because all these three PIL, they are concentrating on the atrocities of the police, my lord. Whether it will be there, company would be there or not, that was not the concern in the PILs, my lord. And even though those people accepting for a moment that the minority of the people, they oppose establishment of the company, my lord, they should not be behaved like this. Their voices should not be suppressed and by help of the police force, my lord. That is my short submission.
Anyone else? Yeah.
I filed an IA for intervention of some of the villagers who were not allowed to enter into the meeting place. They have filed an affidavit that they were not allowed.
What is this IA?
3355, my lord. It has not come up. I have already given the copies. 3355 IA. They have come up to the court and have filed their affidavit in Annexure 1.
So 12 of them, is it?
My lord. And my lord, I have also filed an affidavit by Ms. Barpanda. You were directed to file. And that is also, I have given a copy with the pen drive. Because prior to the date of the meeting, the Tahsildar and BDO are going to the village and making documents, predated documents are being made.
Sorry?
And prior to the date of the meeting, on the 4th of evening of the 4th of this month, the Tahsildar and BDO are moving in this village and creating predated documents. On that affidavit, Annexure 1, my lord mentioned. And she intimated my lord's office through mail about that incident. Documents of dated 5/3/2020 has been prepared on 4th, evening of 4th, by the Tahsildar and BDO, where it has been declared that there is no objection by the villager for destruction of the betel vines. They have given it on their own consent. Their compensation has been granted. There is no police atrocity. Even the daughters and daughter-in-laws of the village are not being allowed, were not allowed. That was not ever communicated to the committee. It was after the committee came back to Cuttack, we came to know that there was a restriction by the Tahsildar that daughters and daughter-in-law cannot attend the meetings.
See, the difficulty is we can't really substantiate these things. How do you substantiate these kind of allegations?
That's the reason why I filed it in an affidavit.
Oh, right.
And I have also supplied videos of the Tahsildar moving around the village. It is clearly audible in that there he is asking for the consents and all this.
So there are 3 affidavits or 4, right?
Well, there are 4 in that Ms. Barpanda's affidavit. There are 4. 2 are for the persons who couldn't attend the meeting, and 2 are the daughter and daughter-in-law of the village who were not allowed to attend the meeting because the Tahsildar had directed that daughter and daughter-in-law are not the citizens of the Gram Panchayat, that they cannot attend the.
There's no citizen of Gram Panchayat anyway.
That is the particular word that the Tahsildar has been using.
Anyway, all right.
And even in the collector report, my lord, if my lord may look into it, the wherever the persons who have objected to this project and have stated that they have faced atrocity, cases are being shown against them, that they have implicated in such cases. The state somehow want to show that these persons are antisocial or something, because there are persons who have been given statement in favor of the company and they have pending cases, and their names are not referred. Their status of their criminal antecedents are not referred here.
In the names that you're going to give, these names are included, Mr. Jena? There are 12 persons here. One of them says that
and these persons are also hiding. They don't have any cases against. The problem is that if they come back, they are being forced to sign the consent for the beetle wines. That is also the predicament over here. They're afraid for more of a reason they are not returning back is this. And these villagers don't have any source of income other than their beetle wines.
No.
They're landless actually.
No, what are the actual facts on this beetle wine part? This land stand acquired under the Land Acquisition Act or do not stand acquired? What is the position on that?
Those lands are government lands and some are forest land. Applications are there for settlement under the Forest Right Act. That has not been settled till date.
Where do we get these facts? Where do we get these facts that these are forest lands?
My lord, from POSCO period that I had during the POSCO period, there was a committee established by the central government, by the Minister of Environment. The report was submitted by that committee that forest clearance has not been taken and forest right applications are pending and that has to be settled. Even in the EIA report that the state government has not filed here, there is a condition in the EIA report that they have to give they have to settle the FRA rights, then only they can acquire the land. That's a condition in there, in the Environment Appraisal Committee approval letter.
So what is the extent of area of land which have these beetle vines? How many? What is the extent of, what is the status of these villages vis-a-vis those lands? Those lands are government lands.
My lord.
So none of them is an owner of that land.
No, my lord.
So what is the real status of these people?
They have been cultivating there for the last 200, 300 years over there. And that for generation together, they have been cultivating beetle vine there.
No, but is it recorded anywhere in a record of rights or anything like that? How do you establish their interest in that land in question? See, one is about residing the village itself. Is the village going to get displaced because of the project?
No, my lord.
So the project is going to come on land which is adjoining the village or nearby the village?
Adjoining the village.
Adjoining the village. And that's government land.
Government land, forest land.
Government. No.
Government
so
land. I
think we'll hear from the AG on that. What is the status? Has the land been actually handed over to the company yet, or Mr. Parijay, can you?
Not yet.
Both
the collector and SP are on VC.
All right.
It's my understanding that the lands are.
If you can use the mic.
I'm so sorry. My apologies. Lands are this beetle vines, which my learned friend is talking about. These are all government lands. And my lord, he is saying that these 5-6 people are not coming back because somebody will forcibly sign. Your lordship may take it from me, my lords, that if they have not signed till now, and without their willingness, and without their signing on a video, we will not get anybody signed. Because what I am told is, my lords, way back before all this started, there was a meeting where the local member of parliament, the MLA, who is a minister, and all the stakeholders were there. And these beetle vines are there from the POSCO time. So some people had left and some were there. So there was a package as to how some kind of a compensation, not only for the people who are growing beetle, and that's on record, and also the people working therein, and also some differential amount between POSCO and now, people who had vacated at that time. So therefore, to say that somebody is forcing doesn't appear to be correct, but then I would not say my learned friends are wrong. So if my learned friend says there are 5, 6, 10 people who he said they are not coming back, somebody would forcibly sign, let him give me a list of that. I assure your lordship, nobody is going to forcibly sign. Because I mean, what is the point in forcibly signing? If somebody doesn't want to give, it's not his land. Then there's another method of doing it. So why should we unnecessary? And on all these monies, as per that document, will go directly to their bank account. So it is not as if somebody is paying cash and etc. etc.
No, I was just thinking, instead of again having another hearing for these people,
lordship pleases,
we'll have them file whatever objections they have in the form of an affidavit.
My lord.
So we'll permit all these 12 people any more people who want to file affidavits, you gather whatever affidavits are possible. We'll compile all the affidavits. Let the collector's report with these affidavits be placed before the MOEF for whatever.
Deeply obliged.
Let them take a call.
Lordship pleases.
They'll get a overall picture of who's supporting, who's opposing. They have these videos. Let them view the videos. Let them, whatever affidavits you want to file, you file it. These 12 people, if they want to, because they are saying that we were denied permission to appear only to voice our objection, correct? So let them file their objection in the form of an affidavit. We permit you to do that.
And as it fell from your lordship, and rightly so, my lord, all this be placed before the central government, let them take a call in the matter.
Correct.
Absolutely.
But our petition is regarding police atrocity.
That's the problem.
And that report of the collector prima facie shows that there is atrocity.
No. I'm so sorry. He says these are the allegations.
These are the allegations, yes.
Allegations. The collector has been truthful to say that these people have made allegations against the police. He is not saying police has committed atrocity. The beetle vines are in the government lands. And my lords asked a question, and rightly so, who owns those lands? They are government lands. They are being paid compensation. So where is the question of atrocity?
There is specific allegation that...
My lord, I was told, my lord, there were 10, 15 platoons of police earlier. And now there is one platoon. If my learned friends say that they admittedly they are objecting to the project, no problem. But then they should ensure peace and harmony in the village, the police will go away. Why should the police go and waste their time?
No, to begin with, you give those names of persons who you think are unable to come back. See, I think on your own showing, see, people who have been able to speak, those who are not able to speak, we're going to permit them to file affidavits. So it's not as if their voices get shut out. All right. I think that assurance, as lawyers, you can tell whoever is approaching you, whatever they have to say now further, you say it in an affidavit. You are able to prepare these affidavits, you help them prepare it.
After that meeting, my lord, persons going, the police threatened them saying that in spite of our warning, you attended, spoke against us, now face the drama.
My lord, may I suggest something? My lord, as it fell from your lordship, something has been captured in that video.
Yes.
Whoever has been left out, my lords are permitting them to file an affidavit. So where is the question of throttling anybody's voice?
Yes. So there's no question at all. You please file the affidavits. We permit you in this order to file that affidavit.
Yes.
You hand over those affidavits. Yes. We'll have a time limit, but it can't be an endless open-ended thing. You file the affidavits within a particular time, within a week maybe.
My lord, the main problem is that they are afraid of that. In one FIR, accused and 3 accused and 500 others. The moment these people come back to their house, my lord, they are afraid, and it happened also in some cases, they are implicated in the case.
Even after
what is the position on this continuing arrests? Why are the arrests continuing like this? What has happened that is triggering this? What are the kinds of offenses for which they need to arrest?
Would your lordships if your lordship don't mind, can the SP not explain?
Yes, absolutely. Yes, please. The SP is there. Yeah.
The question is to the SP. I think he can't hear.
Can the SP speak, please?
The collector and SP are there. Can you hear?
Sir, are we audible?
Now you are. Now you are. Now you are. Maybe we are not audible to them.
Oh, possibly.
Okay.
I'll ask somebody to call them.
Because they are audible to us. So
Sir, yes, sir. We are audible. Sir, so SP will speak now.
right. So the question is this: are you continuing to make arrests in the village?
No, sir. Very few people were arrested, sir.
You're not audible, sir.
I think he can remove his mask if you lordship.
And you can take off your mask, sir.
Sir, very few people were arrested, sir. After 14th Lathi charge, sir.
Still not clearly audible, please.
Sir,
come close to the mic, if possible.
Sir, after 14th Lathi charge, sir, only 6 people were arrested, sir. And after 14, sir, we have arrested, sir, total 6 or 7 people, sir.
No. What is triggering the continuing arrests like this? What was the what have you recorded?
Not, sir, continuous arrest, sir. Some people are involved in heinous crimes, sir. Many criminal cases, sir. In those
these are crimes relating to previous incidents or this particular incident.
No, sir. Some are previous incidents, sir. Some are recent incidents, sir. In recent matter, sir, one Manas Vardhan was arrested, sir. It was totally a election-related matter, sir. Not JSW or any other land order, sir. We arrested one person, and one was with him. He was involved in 15, 16 cases. We forwarded him, sir. 3 people, others were with him, sir. We released them 3 people, and they are living in village, sir.
No, let me just give you an example. One affidavit has been filed today before us by a Pravanjan Das. All right, he's 22 years old. He says his father, mother, sister have all been arrested and are in jail. Is that right?
Sir, I am not confirmed, sir, about Pravanjan Das, sir.
No, I'm just asking, sir, concerned with this incident that happened on 14th January.
Sir.
Are you continuing to make arrests?
No, sir. After 14th January, sir, only 2 or 3 people arrested. No one arrested in 14th January matter, sir. Some people arrested in 127 by 21 case, sir. 4th December 21, sir.
Sir, we want to inform you that according to the counsel for some of the petitioners here, how many people? 30 people.
30 people.
There are still 30 people who belong to the village but who are outside the village fearing arrest. So Mr. Prashant Jaina, who's a lawyer for them, is saying that by Monday he will hand over the names of those 30 persons to Mr. Mohanty. Right?
Sir.
Can you confirm any of those persons are likely to be arrested by you once the names are furnished?
Sir, one thing, sir, one point I will make, sir. Council gave, sir, 85 people list, sir. Last time he gave, sir, 85 people's list, sir. Only 4 are not present in village, sir. Only 4.
No, but those 4, those 4, are they likely to be arrested by you if they come back?
Sir, those 4 are involved in many criminal cases, sir. 15, 16 cases, sir. In investigation process, sir, if evidence will come, sir, then we will take action, sir. Otherwise not, sir.
So can you then file an affidavit, instruct Mr. Mohanty, you file an affidavit regarding those 4 persons? At least Mr. Jena will know what is the cases they are.
We will file, sir.
All right. Likewise, these 30 names which he gives to Mr. Mohanty, you please examine those names and find out which are the names concern people who are involved in previous cases.
We will do, sir.
So, Mr. Jena, let's understand this very clearly.
That will be done by Wednesday.
That's right. Let's be clear on this. If they are wanted in earlier cases, then the law has to take its course. Then you are the lawyers, you know what to do. If it has nothing to do with the previous cases and the apprehension is only after 14 January, he can tell us clearly whether they are going to be, anything's going to happen to them.
Before 14 January, on 4th December, there were some incidents relating to all
Anyway, this petition which we are now concerned, or we have been approached by all of you after 14 January.
No, in my petitions is 4th December also there.
I know, I'm saying, but by the time you filed it and we took it up.
Yes, basically 14 January.
So what we'll do is, therefore, we'll keep it for another day.
Lordship,
Let
please.
all this
Lordship,
exercise be
please.
completed.
Lordship, please.
You say pursuant to the order passed by this court on 23rd February 2022, a meeting did take place in village Dinkia on 5th March 2022, where the panel of 5 advocates were present and 69 villagers made statements before them. A report has been placed before this court by the Collector Jagat Singhpur, dated 7th March 2022, enclosing a gist of the statements made by each of the 69 persons, which would include the Sarpanch Shri Kishore Chandra Parida. 16 of these speakers narrated the police atrocity in the village and were opposed to the project, according to this report. The court has also viewed the video taken of the meeting, which shows the villagers speaking. Paragraph. An affidavit has been filed, an intervention application IA 3355 of 2022 has been filed by Mr. Omkar Devdas, advocate, whereby praying that 12 individual residents of the village, Dinkia, desire to be heard and make submissions. Full stop. The affidavit of these 12 persons have been enclosed with this application. Paragraph. As far as this application is concerned, since the 12 interveners desire that their voices should be heard, the court considers it appropriate to direct that instead of again arranging another hearing for them, the affidavits to be filed by each of them expressing their views be permitted to be placed on record, with copies to Mr. D.K. Mohanty, learned additional government advocate. Full stop. Another affidavit has been filed by Ms. Sarita Barpanda, along with which there are affidavits of 4 persons who again state that they were prevented from making submissions before the panel of 5 advocates. Full stop. The court permits the said 4 persons also to file their affidavits expressing their views, both in relation to the incident dated 14 January 2022 and generally about whether they support or oppose the project. Paragraph. The court makes it clear that apart from the above persons, if there are any other villagers who wish to file affidavits, they should all do so on or before, file affidavits with Mr. Mohanty, additional government advocate, with copies being placed on record before this court through their counsel. They should do so on or before 28th March 2022. Full stop. Mr. Mohanty will then forward these affidavits to the Collector Jagat Singhpur, who will, under the cover of a letter, place all these affidavits along with the video of the hearing of the meeting that took place on 5th March 2022 before the Ministry of Environment and Forests, which is still seized of the matter, full stop. From the affidavit dated 7th March 2022 of the collector, Jagat Singh Pur, it appears that both in relation to the industrial proposals recommended by the Environment Appraisal Committee (EAC). What is Indus 1 and Infra 1, all that? Industry for Industry 1 and Infra 1. The matter is still seized off by the MOEF. Full stop. Is the MOEF a party in these petitions? No.
No.
Paragraph. Mr. Prashant Jana, Learned Counsel, appearing for the petitioners in writ petition civil 1429 of 2022, states that the list of around 80 persons, 30 persons who are still outside the village and are apprehending arrest if they return to the village will be provided to Mr. Mahanti not later than 16th March 2022. Full stop. He had earlier submitted a list of 89 persons, 85 persons. Full stop. The Superintendent of Police, Jagat Singh Pur, who appeared before this court in virtual mode, informed the court that of the said 85 persons, only 4 were not found in the village, and the other 81 had returned to the village. He states that before the next date, an affidavit will be filed in regard, placing on record the details in regard to the cases pending, come up relating to past incidents, that is incidents prior to 14 January 2022, where these persons are involved and for which criminal cases have been registered. Full stop. The SP further states that in relation to the 30 persons whose names will be furnished, he will examine them and indicate if in relation to any of those names there are any previous criminal cases earlier than the incident of 14th January 2022. Full stop. He states that after 14 January 2022, only 4 persons have been arrested. Sir, how many persons were arrested after 14 January?
Sir, after 14 January, sir, exact figure I am not having, sir. But
all right, you place that on record, sir. You place that. He states that in the same affidavit, apart from furnishing all of the above details, he will also indicate the names of the persons and in the cases in which they were arrested, after 14 January 2022. Paragraph. Anything else you want?
My Lord, in WPC 13116, I have made a party to the Ministry of Environment.
All right, that's fine. So we'll have this again. On 6th April at 2 p.m. 6th April at 2 p.m.
My Lord,
6th. What about 7th?
7th April.
Lordship, please.
My lord, regarding this, I may draw your attention, my lord, in double piece number 6653. 3 persons from Trilochanpur village, those who were present in that meeting, in 5th meeting, when they come back from the meeting, the public hearing, they were threatened that why, irrespective of told you that you don't tell anything against the company, why you tell so you will be behind bar.
What has happened to them? Have they been arrested or anything?
No, they are threatening by the police.
Anyway. You've given a copy to Mr. Manti?
Yes, sir.
You've got a copy of this petition?
No.
Just give him a copy, sir.
Given copy to government.
Just give it to Mr. Manti. Let him take instructions. All right. List on 4th. All right. 7th April at 2 p.m.
Lordship, please.
Right.